anyone in attendance. Can the department please remove the presentation? There's internal business that we need to do before the presentation. Thank you. The chairperson is about to log in. Thank you.
Hello? Hello?
Hello.
Good morning, members. The chairperson seems to experience some technical glitch. Let me phone her again. Just a minute. Sorry about that.
Okay, sure, Lindy.
Good morning, honorable members.
Good morning, Chair.
Morning, Chair.
I really apologize. We were born before technology. I don't know what is happening. In fact, it rained the whole night. I think the network is not on my side. I really apologize with these 10 minutes that we are behind. I will try our level best to cover it up. I sincerely apologize for that. Honorable members, I hope you have apologized for me. Honorable Masango, I see you.
The Secretary apologized on your behalf, Chair.
We
Thank
accept
you
the
very
apology, Chair.
No problem.
We move to fourth industrial revolution. So have gets up.
Thank you very much. I will try to cover up that 10 minutes that we're late with. I will log in at 7:30 this time around. Thank you very much for that, accepting my apology. Morning, honorable members, morning officials, and whoever is present in the meeting. I'm not sure whether the minister is with us or not. Lindy, can we then bow our heads where we are just a minute or a second? Thank you very much, honorable members. I wish to welcome everyone in the meeting. Today is not really my day. I need to apologize up front if I made any blunders. It's because of humanity, and as women, you know the problems as mothers that we are encountering at times. but everyone in the meeting is really accepted and welcomed. The meeting is officially opened. I also wish Lindy, can you flight the agenda so as not to waste time?
Chair, I'll do so.
Thank you very much for putting forward my apology.
Yeah, welcome, Chair. Can you see the agenda, members?
Not yet.
Hello?
Not yet.
Not yet.
It's coming through. It just
Hello?
shows it.
Yeah, it's coming.
Oh, I think I've got a bit of a network problem. Hello?
Okay.
It's darkness. Okay. It's in now, Chair.
Yeah, we can see it. Yeah, welcome. Has been done. Confirmation of attendance. Can we get who's in the meeting? Okay, Lindy.
Thank you, Chair. We have you, the chairperson of this committee, Member Mbana. We have Member Abrams. We have Member Iris. We have Member Shongo. We have Member Fanda Merve. We have Member Stock. We have Member Opperman. We have Member Masango. We have Member Mare. If I omit any member, I can confirm that. Chair, I also want to confirm that we are a quorum. We have 9 members out of 12. Thank you very much, Chair.
Okay. Thank you very much, Lindy. Can we then go to apologies?
Chair, firstly, I have an apology from Member Sukers who is unable to attend today's meeting due to prior commitments. I see the minister is here, but let me omit the apology that was submitted before, but she's here. There was an apology for her. Thank you very much. Those are the 2 apologies.
Okay. Thanks, Lindy. It means we are a quorum. We also want to acknowledge the presence of the minister. We know that it's Wednesday today. There might be a cabinet or something. There is a lot to do, but we appreciate her presence with us. Can we then go straight to the adoption of the agenda?
Chair, I move for the adoption. It's Honourable Van Merwe.
Okay, Honourable Lizette has adopted the agenda as it is. And then any seconder?
I'd like to second the adoption of the agenda, Chair. It's Bridget.
Thank you very much, Honourable Masango. Then, if it goes like that, let's just go straight to the briefing of the department, knowing exactly that it's really...
Recording in progress.
They are, I will say they are privileged to present this report after the presentation of other departments in terms of what has happened in the public hearings. We got the Home Affairs report. We also got other departments report, health, etc. So they are really in advantage today to present their report to us. So we have given them plenty chance to present the report. Can we then give over to the minister first?
Thank you very much, Chairperson, Honourable Chairperson, and I must apologize that my network is extremely poor. It's very windy where I am, so I will not put on the video. But also upfront, Chairperson, as you indicated in your opening remarks, we have a special cabinet taking place right now. And so I will just open the meeting and hand over to, well, I won't open the meeting, sorry. I will just request that the department, because the meeting has been opened already, I'll request, and it's not my meeting. How can I say I'll open the meeting? My apology, Chair. I will ask the department to remain and make the necessary presentation. And so attending this meeting, Chairperson, is our Acting Director General, Mr. Mchunu, the Executive Officer of SASSA, Dr. Memela Kambula, Acting Executive Officer for the National Development Agency, Mr. Bongani Magongo, and then the other senior managers and officials will introduce themselves, and entities will introduce themselves, as I guess they did even in the previous time that we're presenting. Chairperson and honorable members, pursuant to the people-centered democracy that we set out to realize in 1994, in May 2020, as well as from September to December 2021, the Portfolio Committee on Social Development conducted thoroughgoing public hearings on the Children's Amendment Bill, which is a very important bill. The amendments seek to address a number of weaknesses in the broader child care and protection system, in particular the foster care system. As the honorable members will recall, and as ordered by the Gauteng Division of the High Court in Pretoria in November 2017, in the matter of Center for Child Law versus Minister of Social Development, these amendments are the basis for the creation of a comprehensive legal solution that would address the menacing foster care challenges. Public hearings are inherent to the inclusive and participatory fabric and essence of our society, insofar as these are the means and mechanisms by which active citizenship can practically be brought to fruition for the purpose of facilitating for people, yes, the people who foreground our constitution when they said we, the people of South Africa, to be the primary sculptors of process substantive consideration and actual laws that this parliament attends to. It is for these reasons that the people are the first, last and only motive that ours is a democracy. Noting that substantive engagements with the diversity of communities are effectively strengthening our institutions of democracy, the Deputy Minister and I know that the apology for the Deputy Minister was submitted. She hasn't been well. She is in hospital, but we hold the fort while she is in hospital. So the Deputy Minister and I are grateful to you, Chairperson, and the honorable members of this committee for bringing the people's felt needs on board this important legislative process, a legislative process that is intended at securing the only place that embodies South Africa's future, our children. And therefore, Chairperson, the state of South Africa's children is a serious-minded matter, such that it ought not to be a party politicking issue. Instead, the state of South Africa's children features so high among our society's tough and unbearable issues that it is a common interest to us all. So serious is the matter that it demands that we all should purposefully deepen society-wide collaboration that are targeted at radically improving the state of all children. And while each and every South African is society's most precious resource, as I mentioned earlier, our children demonstrate how invaluable the embodied future worth is, resource actually is. I would like to reassure the Portfolio Committee that I'm treating the outcomes of these hearings with the highest esteem they require. Consequently, the department must direct heightened levels of seriousness and urgency when attending to the outcomes of foregoing public hearings. And I'm aware, Chairperson, that we came here, members were unhappy with some issues. We are back here again. And I would like to say that as long as you see weaknesses in the system or weaknesses in the work that we do, we appreciate the work that you do as members of the Portfolio Committee and your oversight over the executive. So accordingly, I have asked the department to thoughtfully attend to the numerous technical and substantive service implementation challenges that the children, parents, communities, practitioners, and our partners raised during the public hearing. Specific questions have been posed by South African children. To these specific, quantifiable and implementable responses are due. I know that the honorable members of the Portfolio Committee and their support staff invested themselves into making sure that the felt needs of the children of South Africa are properly recorded and transmitted to the department for sufficient responses. I expect nothing less in the presentation that you will be receiving this morning. And again, Honorable Chairperson and Honorable members, I thank you for your personal investment in this process. And Honorable Chairperson and members, please receive the department's response to the national and provincial hearings on the Children's Amendment Bill for your due consideration. And I apologize that I have to step out, but I'm sure that I will get the necessary briefing thereafter. Thank you very much, Chairperson. There's something flying on your face. Oh, it's gone now.
It's
I got
gone. It's gone. I am in the village.
Oh.
So you'll get the flies and everything.
Yeah, no,
and
those things.
butterflies.
Thank you, Chairperson. Thank you, honorable members.
Thank you very much, Minister, with wonderful opening remarks, which we hope all the best for your day, understanding the work that is confronting you as acting Minister of Women, Youth, and People with Disability. And also, I wish to say to the social workers, happy belated National Social Work Professionals Day. Yesterday, they were celebrating their day, but unfortunately, we managed to send our voice of saying happy National Social Work Professional Day. We are excusing you, Minister. We hope that all will be the best. We won't be disappointed this time around. We were not really happy about the presentation last time. We hope everything is going to go well for now. As I have said already that we managed to get the reports from other departments, which means that Health Department has given us a clue, and also Home Affairs has managed to give us some clue on what needs to happen. So they will just polish up those issues for us. Thank you very much. Let's proceed with our meeting by giving over to the acting DG, Mr. Mchunu.
Honorable Chairperson, members.
Can I be allowed to switch off the video so that I can be able to deal with these flying things that are being seen by the minister? Thank you. Thank you. Over to you, acting DG.
No, thank you very much, Honorable Chair. Please don't be surprised if you see any flying things here as well. We're in Swane, and yeah, let me leave it at that. Thank you very much. Honorable members, let me firstly just start by indicating that indeed, Honorable Chair, we appreciate the fact that the committee has noted and indeed congratulated all social workers from World Global Social Work Day yesterday. We really appreciate that, and we continue to send out our much appreciation for the hard work and dedication that social workers continue to do on a daily basis. Yes, we may note it only on the 15th of March, but for us, every day is an important day for social workers in the life of South Africans as they work tirelessly to ensure that South Africans are assisted in the challenges that they face in a myriad of areas. So we thank you for that, and we thank the committee for noting that. Let me also appreciate, Honorable Chairperson, the indulgence of the committee on our previous challenges that we had with regards to the presentation. We are confident that this time around we didn't miss the brief, as it were, as we did the last time, but we are very confident that we've done the right thing. We've had numerous consultations, including with the content advisor and with the legal team, to ensure that we provide a report that is succinct, or rather detailed, not succinct, but detailed, and deals with all the issues that have been raised in the public consultations as per the request of the committee. Now, Chairperson, you would note that there are three, Leandro, if you could put the presentation on, there are three attachments that we sent. The first one really providing an analysis which is really high level, which talks to context in terms of issues raised through the submissions. It also talks about the categories of the or groups rather that made the submissions, being private persons, refugees, migrants, groups, professional associations, academic institutions, traditional leaders, children's organizations, gender groups, Chapter 9 institutions, and of course faith-based organizations, which are critical in Luanda, can you put on presentation mode, please? Which are critical to the work of social development, and more so on the issues raised with regards to the submissions. And of course, we received both oral and written submissions. And just to indicate that the key issues that emerged, of course, were around foster care, adoption, parental responsibilities, ECD, children's rights, children with disabilities, issues around unaccompanied and separated migrant children, amongst others. And of course,
if they would be most probably
Nelly, can you mute, please? The second attachment, honorable members, that you would have received is about an 88-slide presentation, which is what we're going to deal with this morning. It really goes into the details of some of the matters, particularly on our observations. And of course, the last one is the matrix, which gives a much more detailed analysis and a much more elaborate, dealing mainly with the specific articulation of the clauses, our recommendations, and our responses to the matters raised through the process. Now, my apologies. Honorable members would note and recall that we started this process around May and concluded it in May 2020 and concluded it in December last year. We've noted all the submissions that have come through, some of which were general concerns made by members of the public, organizations, and children, parents, etc. I've already highlighted the stakeholders. And I think the Children's Amendment Bill seeks to address some of the gaps in legislation, court judgments impacting on the Children's Act, and most importantly, as the Minister would have raised earlier this morning, is that the issues around our response to the North Gauteng High Court order on the comprehensive legal solution to address the foster care backlogs. And we're hoping that before the end of the year, we'll be able to move on that legislation. Go to the next slide. Now, Chair, I think it's important to just highlight that there are all the ECD clauses that were dealt with in the children's will be dealt with, or rather in the Children's Second Amendment Bill, which is led by the Department of Basic Education. We of course, members have rejected that aspect of the bill. It's the DBE by virtue of the ECD migration taking place at the end of this month to basic education and social development. We will be working very closely with the DBE as the handing over department in that regard. And that's just to also indicate that we've established a task team, which we reported last time to the committee, to advise on very specific issues around ECD. There have been regular meetings in this regard, and progress will be provided outside of this forum in terms of progress recorded in that regard. Then lastly, just to indicate that, maybe you can go to the next slide, actually. I'm summarizing just these high-level slides so that we get to the crux of the work. Just in terms of observations made during the public hearings. Now, it's important to just highlight that although the consultations were made to solicit comments on clauses of the bill, we received a number of other comments that the public raised, particularly as it relates to service delivery in government on the whole. And some of the issues were historic, systematic, whereas others were operational, relating to service delivery.
DG, can you then do the presentation in the slideshow and remove the small one on the other side, on the right-hand side?
Okay.
Thank you.
What is it showing? What is it showing like on the screen there? It's showing the size of the station now.
No, you
Now? Don't touch it, just tell me what it's showing.
you've got blank and one that's showing two actually. It's still showing.
Now?
It's still,
Now? Find out.
no, it's not.
It's better, but increase the font. Here,
Yeah,
back to normal, back to square one.
I know.
No, it says no. Yeah, it's fine.
Thank you very much.
No. Thank you very much. Chair.
Continue.
Thanks. It seems I'm the only technician here born after technology. After technology. Thank you very much. Leander, can we go to, yes, the slide. So I was just indicating that some issues raised, as I already indicated, were systemic, historical, and some were operational, relating to service delivery both within the department and other organs of state or government in the whole, as already indicated, with some having a ripple effect on children. And then amongst other things, what is key to highlight is that the issues around the capacity of the state to deliver on its mandates in the context of human and financial resources is important, but also in terms of coordination across all three spheres of government and across various government departments and agencies, including stakeholders. I think that's a fundamental aspect that came out. The manner in which we coordinate our work as it relates to children's issues, not just as government, but also with regards to stakeholders. I think that's an important aspect that really came out. And then, of course, the issue of capacity of social workers, the critical issue we continue to raise, and we're engaging currently with the National Treasury on a strategy in terms of how best we can absorb social workers. Now, this may be a long-term aspect, but in the short term, what we are doing is we're finding very creative ways through the Presidential Employment Stimulus Package and other measures to ensure that we employ social workers, but we want a much more permanent solution via additional funding coming from the National Treasury. We're actively lobbying in that regard. I'm not going to go to the next slide. Safe to say that we do acknowledge the challenges raised about the provision of services by the department and government in general. However, we are going to focus purely in this presentation on issues that relate directly to the bill, whilst other matters are being brought to the attention of the relevant authorities in our respective provinces. You can go to the next slide. This is just in terms of the nature of the comments I've already highlighted. There's some that fall within the scope of the bill, some that fall outside of the scope of the bill, which are intersectoral, and some that fall completely outside of the scope of the bill, but within the mandates of the department, such as substance abuse, gangsterism, etc. And these are issues that we find the time and space to be able to address. In fact, the issues that we're addressing on a regular basis, but as I indicated in this presentation, we're really just going to focus on the specific, on the amendments to the bill. And then, of course, I already highlighted the importance of coordination, but the critical thing is around the need for us to, strengthen education and awareness of the provision of our services, because in some aspects you would have found that some people actually don't know that there are services that are rendered by government and where they can access them. And I think that that's one of the critical things that came out. Just in terms of general observations, just that there are matters that are covered within the Children's Acts, but not within the amendment bill, and I already indicated that. But in this space, we're only going to focus those that cover the Children's Amendment Bill. Other issues like virginity testing and circumcision, etc., are critical matters, and we are addressing those in a different manner outside of this particular presentation. And then I will skip the next slides because it's essentially things that I've spoken to, just the matters that fall out of the scope of the presentation. Chairperson, we're going to go into the thrust of the presentation now. We'll deal with the entire presentation, and I'm going to ask Luyanda to go and take us from slide number, what is that? 14, I think it is. Yes, this is the one. Please go ahead, Luyanda. Thank you very much, Honorable Members. You can, no. Yes.
Good morning, Chairperson, honorable members of the committee, Minister. As indicated, Luyanda is my name. I'll be presenting on the issues that have been raised during the public hearings. And one of those issues is the adoption. The organizations that presented on this, just to highlight aims, is Wandisa, ABBA, Mr. Nuwairo, Professor Ed Skelton, the Center for Child Law, Law of Hope, SASWIP, COMSA, Catholic Institute of Education, Kangaroo Adoptions, AFM Welfare, DAXA, Solidarity, Child Welfare South Africa, Women Legal Center, Child in Distress, that is Grindi, Media Monitoring, and We Are Fathers, We Are Parents. It is important to give this information in recognition of the huge work that civil society has played in shaping the status of this particular bill. What is key that was raised by these organizations, some of which are common and some of which are unique to a particular stakeholder, was the deletion of section 249 and charging of fees. You will understand that when one is transacting an adoption process, there is a need to involve a number of professionals like social workers, lawyers, medical practitioners, and all that. So there is an issue around the deletion of section 249, which talks of the charging of fees, which we are going to explain in slides as to our response to that. The link between adoptions and child trafficking, which has also been indicated that there is no link. That is, the people who presented indicated that there is no link between the two, or there is no evidence to that effect, and we'll be responding to that. The delay of recommendation as contemplated in section 239 of the Children's Act, which the HODs have to do when an adoption process is taking place. The lengthy adoption process, why does it take so long? That is proves to us why does it take so long to process an adoption, and the decline in numbers of adoption. It was indicated that maybe because the department is not doing sufficiently, that is why there is a decline in number of adoptions, which we have a response to that as to why the specialization in adoption, because there was also an issue that adoption is a specialty and it cannot just be done by anyone, and the issues of temporary safe care whilst a child is awaiting the finalization of an adoption transaction. Moving further than that, we must take into account that Clause 132 seeks to delete Section 249 of the Children's Act. This amendment is intended to delete reference to all fees that may be charged, as we had presented some time earlier before your August committee, Honorable Chair and Honorable Members. The rationale behind this amendment is to harmonize the provision of adoption services with the rest of other services in the Children's Amendment Act. Why we are saying that? We are saying The Children's Act has got a number of services that relate to the protection of children, adoption being one of them. But nowhere in the Children's Act do you find the reference to fees for other services that are there. So it's a question of harmonizing the provision with the rest of the other provisions in the Children's Act. And we further indicate that as a department, we reject the proposed amendment that we must reinstate Section 249 of the Children's Act based on the number of reasons that we are advancing, which are one, that the deletion of this section has nothing to do with prohibiting lawyers, social workers, and other such professionals from charging fees for services they render during an adoption process. It has got nothing. The deletion itself does not relate to a prohibition. When something is silent in legislation, it does not mean that this is prohibited. Lawyers are charging their fees in terms of their own respective professional body. That's why we are saying fees by professionals for rendering services are dealt with by their respective professional bodies. We understand that during the commentary, when the committee was moving around, there was an indication that it will take much time to establish these professional bodies. And I think there is a misunderstanding in that respect. We are not, as a department, in any way saying the professional bodies must be established in order to cater for the charging of fees. We are saying the professionals that are involved in the provision of adoption services already belong to their own professional bodies. So those professional bodies are already in existence, and they are the ones who must pay to the fees. What I'm trying to bring here is we are saying whether the issue of fees is mentioned or not mentioned in this particular legislation. Lawyers will always charge fees for the services they render. Medical practitioners will always charge fees in terms of the services they render, based on what their own council or society is prescribing them in terms of charging fees. So there is not going to be any professional body that is still to be established. The reference to professional bodies is in terms of existing professional bodies which these professionals belong to. So we are therefore saying there is no requirement for the establishment. It is therefore incorrect to say that the establishment of these bodies or council will take too long, as there is no merit in this particular issue. Again, as I indicated, that the deletion of Section 249 does not prohibit professionals from charging fees as indicated. So over and above, the department has taken a decision to manage adoptions in-house in order to mitigate the challenges of child trafficking, abduction, child slavery, and the charging of exorbitant fees. Because there is so much in terms of the fees that get to be charged. One website went through, the fees that get to be charged, they go close to R500,000 rands being shared, of course, amongst the professionals that are involved. And it shouldn't be like that, because at the end of the day, we must also ensure that we are looking at issues of possible child trafficking when money is involved. And we said, as a department, this is not a department's position per se, but it is a reconfirmation of a position of the Inter-Country Adoption Convention, that is the Hague Convention. Because in its very preamble, the convention is indicating as follows, I quote, "Convinced of the necessity to take measures to ensure that inter-country adoptions are made in the best interest of the child and with respect for his or her fundamental rights, and to prevent abduction, the sale of or traffic in children." Abduction, sale of, traffic in children being our emphasis. It It is not the department that is saying there is a possibility of child trafficking in adoption services. It is the Hague Convention itself. If we go beyond that and look at the explanatory memoranda to the Hague Convention itself, this issue was raised, and it has always been there that we must be circumspect when we deal with issues of adoption, as there is a possibility of these issues that have been indicated. Further than that, the Hague Convention itself is very clear. There is no entitlement to inter-country adoption, that a child must be taken to another country and all that, which is what we understand as reading the Inter-Country Adoption Convention as a department, because there is a principle of subsidiarity that is very much entrenched in the convention itself, which says family first. If any person wants to transact a child through inter-country adoption, it must be clear that the family first was considered, because the issue of inter-country adoption must be a last resort. Family must have been considered first, and family is broader than just the biological kinship and all that. It extends, to the extended family and the community at large and all that. And if that fails, there must be domestic possibilities that must be considered. That is in terms of this particular article, but recalling that each state should, as a matter of priority, which is our emphasis, as a matter of priority, appropriate measures to enable the child to remain in the care of his or her family of origin. We were trying to put things in shape as a department to say, there has been so much that has been happening, because there must be proof that indeed family first was considered, because we are domesticating a Hague Convention here, as indicated in the Children's Act, that the Hague Convention is law in the Republic. So it has been domesticated, and we need to practice inter-country adoption exactly in that fashion. We must not make inter-country adoption as an issue of first instance. It must be an issue of last instance, as these articles are indicating in the convention itself. And we must also recognize that, as indicated in the article, that inter-country adoption may offer the advantage of a permanent family to a child for whom a suitable family cannot be found, where a suitable family cannot be found in his or her state of origin. So we need to have that being recorded in that context, Honorable Chair and Honorable Members, that a person who is transacting a child through an inter-country adoption process must be able to take the department into confidence that a suitable family cannot be found in his or her state of origin. Otherwise, if there is a prospective adoptive parents register, that is where parents are looking for adopting children, and those parents are not considered first before we go for inter-country adoption, we will not be applying the law as it is required, because the inter-country adoption is telling us that we must consider the state of origin first before we can go across the country. There is also an issue that we were indicated around the child trafficking and all that. There have been questions in the past that are being asked. Is there a research in this issue that there is a link between child trafficking and inter-country adoption? Yes, there has been research, Honorable Members, Honorable Chair, Minister. There has been research that has been conducted across the globe, but some of the scholars that we can just enumerate from that list is John C. Brook, and then David Smolin, in the journal articles that are entered in the Pareto University with regard to the work of C Group. There is an indication that inter-country adoption has always been event-based, if we start from there, and not, and a humanitarian issue and not a fertility issue. What in principle that means is that even the manner we are dealing with the issue of inter-country adoption is not consistent with what its original purpose was. Because the original purpose was more humanitarian. When something very bad had taken place in a country, that's what John Group is saying in the New Yorker, where his work is recorded. It's not the department again that is that, but is confirming that position, which it also subscribes to, that indeed there should have been an event. There are examples that are listed in that particular work by John Group to indicate that this is what happened during the Second World War when children were destitute and having no parents after the war. This is what happened, after the war in Vietnam. This is what happened after the war again in Korea. This is what happened during the takeover of Cuba by Fidel Castro from Batista. This is what happened in China when the new one-child policy was introduced. And the list goes on. This is showing us all the events that took place before a humanitarian approach would be considered in terms of taking children over to another country for adoption issue, not just an issue where a particular parent in California is interested in adopting a child in Guanongoma. It has not been that particular case or an environment. It has always been a case where humanitarian issues were considered. And it has always been a political issue at the time until it became an executive issue when the convention came into force. And again, still in that context, the executive is the one that is going, is having the responsibility to implement these international conventions. So it is important to indicate that it is based on this particular issue to say the executive will have to take a decision in this regard, looking at all the possibilities of challenges that exist around the world in order to ensure that the inter-country adoption is taking place. Again, with regard to David Smolin, who confirms what the group is saying, there is also an issue around that these are the decisions of the states to take what steps must be taken around inter-country adoption or the implementation of such conventions. It is not necessarily an individual kind of a situation where a child protection organization or an individual would decide that, no, I want my child to be adopted in this particular country and all of that. So what the department is trying to do is to implement the Hague Convention in its correct form and also practice the inter-country adoption in its correct form. We must also understand, as I indicated there, that this has always been event-based. Even the Honorable Minister then, Dr. Zogospreya, may his soul rest in peace, when he came to sign the inter-country adoption, to counter-sign it when it had to be signed by the president, and when it happened that the guidelines for inter-country adoption were published, he said the reason why the Republic of South Africa is signing the Hague Convention on Intercountry Adoption is because of the overflow of orphans that are caused by HIV and AIDS in the country. That was the rationale for signing the Hague Convention, not for any kind of a situation, because he was fully aware of the principle of subsidiarity when it comes to these issues, that family must be considered first, and the issue of crossing the border must be the last resort. Rather than that, we also have the challenge around Section 239, the recommendations that have to be made and approved by the HODs if there is, everything is in order. So there was an indication that there is a challenge. These recommendation letters are supposed to be issued within 30 days, but it's taking longer than that. And we can say today that, well, the Director General has written to all the HODs to indicate that, and the matter is under consideration. The HODs are aware. So it was quite just an issue of implementation rather than the issue of an amendment of the law. Hence, the DG had indicated that in the beginning, some of the comments fell outside the ambit of this amendment. Better than that, there was an issue of lengthy adoption process. There was a complaint from day one. Why does it take so long for an adoption transaction to complete? We must understand, Honorable Chair and Honorable Members, that there are different processes that ought to be followed in adoption, depending on the categories, of course, of children as per the adoption practice guidelines. What is key is the best interest of the child, and then again, there are so many external dependencies when it comes to an adoption. Social development may play their role as social development, but tracing, which is done by someone outside the department, we as a department have no control over that, but we are trying our best at all times to ensure that this happens within the agreed period of time. The police clearance, which is done by the police, we may not have a control as a department as to for how long the Department of Police must be able to provide us with the police clearance, the screening of biological and adoptive parents, adoptability assessments, the court processes alone, because the magistrates have got their own diaries, which we don't have control over. We cannot tell a magistrate that, as a department, of course, that this process must not take longer than 30 days. So I think there is something that we need to do more as a department. We're not trying to be dismissive, Honorable Chair and Honorable Members, when we present this particular scenario, but we are trying to indicate that where there is an external dependency, it is not easy to deal with these issues, but we are working very hard to ensure that we are addressing these issues. Of course, that's an issue of intersectorality, because this is an intersectoral arrangement. We've got different departments that are involved, or different organs of state, if I may be precise, that are involved in all this. So that is why roughly an adoption process would take about a year, with all the shortcomings it has, but the department is really working on that. There was also an issue around the decline in the number of adoptions that we have as a country. One of the issues that was raised was that the reduction of numbers may be caused by the challenges the department has. And we are saying with regard to that, no, it's not necessarily about the challenges, although we do acknowledge the challenges as indicated in terms of the issue of intersectorality, but also the decline when we viewed the global status is as a result of countries getting wiser about the link between inter-country adoptions and child trafficking and other such related matters. There is a decline, not of adoptions in the country alone, but a decline of inter-country adoptions across the globe. The decline is not caused by, as has been indicated during the hearings, of an inter-country adoption sentiment or just domestic adoption sentiment, but a realization of the risk associated with the process, including child trafficking, which we have spoken to as the articles in the Hague Convention and also the preamble thereto. The issues of possible abduction, the mining of body parts, forced child prostitution, drug mules, and such related instances, which have made countries to reassess their status when it comes to inter-country adoption issues. There has also been an issue of improved social security systems in different countries, where countries have improved their social security systems, as we indicated at some stage when we presented before your good selves, Honorable Chair and Honorable Members, to say even South Africa has a good social security net that can take care of the children as from the domestic perspective, as we indicated that if the family is not possible, but domestically, we also have to deal with that. So it should also be noted that priority is given to parental care. That's another cause for decline. The priority is given to parental care and family preservation, which is a principle of subsidiarity that we alluded to earlier. And adoption is the last resort, and that is a personal choice and cannot be imposed on an individual. However, the department remains committed to creating an awareness on adoption, because one of the issues that we picked up was that during the hearings is that some of the issues that the department or the programs that the department is providing are there. It's just that people are not aware. So in that context, there is a need for more awareness raising. If you may look at this particular slide, Honorable Chair and Honorable Members, you will take note of the fact that, as I indicated, that the decline in numbers of adoptions is not a South African issue, as it was alleged during the public hearings. It is a global issue. All the countries in the world, as I indicated, are getting wiser and wiser each day. If we look at what was happening in China in 2004, you will see there were 7,038 cases of adoption. But when you look at the case scenario in 2018, 1,475. So there is a decline. And the reason for that is because China is busy. In fact, at the time, China was busy amending its legislation so that it tightens the screws that are loose in the inter-country adoption system. Because this status is more on inter-country adoption cases. And even if you look at Russia, Russia had 5,862 cases in 2004. But in 2018, China, 2017, 0, 2018, 0. And the rationale for that was that China took a decision that, Russia took a decision that Russian children must be raised in Russia. And that is what they said. And they amended their legislation accordingly. That is why they are sitting at 0, because they that they spotted a challenge in the adoption process. So the list goes on as those countries, I may not go to each country, but what I can say is a summary with regard to all these countries. The reason for the decline in adoption cases has been caused by the realization that there are challenges in the adoption system, more especially in the country adoption services, and these countries are amending their legislation in order to tighten those screws that are loose in the process, as we hereby do as the Republic of South Africa, to say we are also subscribing to that information, that indeed there are challenges in this space. So that is the reason for the decline of the cases on adoption. It's not an anti-adoption sentiment. It is the reality that is taking place out there. Because, for instance, in Russia, one of the cases that made Russia to take an instant decision was when a child was adopted in America, and that particular child was just taken back home alone, a 12-year-old, in a flight with a letter in her school bag, to come back to Russia. And then that was the end of the transaction. And Russia took a decision around that particular issue. The specialization in adoption services, the department is providing ongoing training to equip and empower social workers who render adoption services. Because there was a lament during hearings that said, no, adoption is a specialty, it cannot be done by social workers in the public sector. It is only meant for social workers who work 24/7, not those who work from 9 to 4. That was indicated during the hearings. So we are saying, yes, we acknowledge that it is specialization, but we must also understand that adoption itself is an inherent child protection service that every social worker is trained to render. It is not a matter of private sector versus public sector kind of a thing. So every social worker is inherently trained in that space, but now the department is augmenting that training with something so that we can, as a department, also provide the adoption services and not allow adoption services to be specifically the function of private sector, because there is no such a thing with regard to all the other services that we provide as a department. These services are provided by social workers throughout the system. So it is incorrect that social workers in government are not competent to deal with issues of adoption. As I indicated, that adoption is an inherent child protection service that every social worker has been schooled in during their curriculum. Again, the issue of placing a child temporarily with the family, with the prospective family, the indication is that the placement may not be in the best interest of the child, as screening is for permanent placement. So we cannot place a child as a department temporarily, because that's not what the screening was all about. And there are challenges, even if we were to do that as a department, there would be challenges with regard to the expectation that the potential adoptee might have, and also the expectation with regard to the adoptive parents. If in the long run things change and the child is already bonding or has already bonded with the prospective family, and it appears that the circumstances in that particular family change before the actual adoption has been finalized, So this may create a lot of challenges and may not be in the best interest of a child, because it would definitely create or will have led to a false expectation and thus have disastrous consequences, not only for the child, but also for the prospective family. That concludes the adoption issue, and further than that, we also received commentary on the amendment bill, on the foster care in the amendment bill, which was, as the minister in her opening remarks indicated, led by the North Gauteng High Court order in seeking the comprehensive legal solution and the amendment of the legislation as the order, what the order indicated. So in this particular regard, we must understand that part of this legislation is being amended because of this order. So it's a twofold kind of an amendment. There are general amendments that were already in the pipeline when this particular order was issued by the North Gauteng High Court. So we also addressed the issue of the foster care challenges and the backlog, which we have always been presenting before Parliament from time to time. The organizations that presented on this, again, with Professor Skelton in her individual capacity, Center for Child Law, Children's Institute, Children in Stress, Concert, Jelly Beans, Give a Child a Family, Stelcare, Stellenbosch, and District Family Services, and SAMCO. So these are the organizations. We must also take into account, Honorable Chair and Honorable Members, that there were also individuals who made presentations, but we don't have the list. In fact, we do have, but we have not put the names of those individuals from all the districts that we visited as a committee, as it would have made this document very much cumbersome if we had to do that. The key issues that we raised around the foster care was, in fact, were children in need of care and protection, particularly orphaned and abandoned children in the care of family member, extension of lapsed to foster care orders in terms of Section 159 of the Act, the monitoring of foster care placement in terms of Section 186 of the Act, caregivers in the cluster foster care scheme, placement of a child with a foster parent who is part of a foster cluster foster care scheme. So with regard to that, as we respond, firstly on the protection, particularly orphaned and abandoned children in the care of a family member, the distinction between children who have bonded with their families and those who have not bonded has to be taken into account. So the department, with regard to that, supports the proposal by the Center for Child Law and Children's Institute and Professor Skelton, so that it will be amended to cater for the proposed amendments if the committee so agrees to that. But as a department, we agree with that proposal. And as we indicated in the opening remarks, there is also a matrix that will go through at the end of this presentation where we show how this has been effected at the end of the day. The extension of lapsed care orders in terms of Section 159 of the Act, there was an indication that the period of foster care extension is an overstretch of the law. There must be a transitional period of 3 to 5 years. That was the comment that was received. And with our indication as a department is that the department does not support the proposal based on the fact that a period of 6 months that we have suggested as a department in the amendment bill is reasonable to allow the magistrates to process the extension of the foster care orders. This is actually in line with Section 48 of the Act, because if the Act says a foster care order must be for a period of 2 years and that can be extended, it would not make a legal sense to extend a 2-year order for a period of 3 years or a period of 5 years. Hence, Section 48 is also giving that kind of an understanding, that Section 48 of the Children's Act, that the magistrates, yes, they do have the power already. Without this bill being in place, they already have a power to extend. So we are granting them that in terms of this amendment bill, that a period of 6 months would be reasonable. We therefore reject the proposal of 3 years to 5 years, because we would be creating a new law if we do that. The issue of monitoring of foster care placements is no longer necessary in the context of this bill. It was also raised during the hearings. The department does not support this view because the whole purpose of monitoring of foster care placements is to serve the best interest of the child. So it is already a key ingredient of the child protection services. There is no way the issue must be reinserted in the bill because it's already there. It's no longer necessary. The department is doing exactly that. With regard to caregivers in the cluster foster care scheme, there was an issue that the division of cluster foster care scheme must include district offices. And the understanding of the department is that the district office may derive that power or function from a delegation by the HOD, because the information or the issue at hand in terms of the Act is that the HOD does have the power, the DG does have the power, and the Act does provide for the DG and the HOD delegate such power to any official in the department. So it would not make sense now to create another way and say the district offices must have that particular power, because inherently, by virtue of a delegation from the DG, those who are in that space will definitely have that power. So the Children's Act does allow, as I indicated, for that delegation, and therefore it is not necessary. So if we were to support this view, it would mean that it would have the word district or local appearing in every provision of the legislation, as indeed all the functions, or the 99% of the functions in the Children's Act are in the normal course of events ordinarily performed by officials in such offices, not necessarily by officials, by the DG or the HODs themselves. So in any event, those officials, they do have that power through delegation of powers, which the Act itself does provide for. The placement of foster care parents who is not part of a cluster foster care scheme, the issue that was raised was that there must be a placement of that parent who is in the cluster foster scheme who is not part of that. So the impracticality of placing a child with a foster parent who is part of a cluster foster care scheme is that it may be easy to deal with this issue at all material times. Hence, the department supports this view and has effected the necessary amendment to the relevant clause in the matrix that has been attached here too, which is part of this document. The other issue was around the Child Protection Register, which is also a thorny issue as per the comments that were received. Again, Center for Child Law, Childline, South Africa, Jerry Beans, DS South Africa, Professor Skelton, Solidarity, Child Welfare Society, Children's Institute, made comments around this issue, and comments, although they led to the same thing, but they varied slightly, and we have addressed that in that context. The issues that they raised, that is the organizations and the individuals we have just cited, whether there is a delay in the screening or issuing of screening outcomes. A much simpler method is already available in the criminal records department, that is the SAPS section. In that way, we can just move back the register to SAPS, and the proposed amendment of section 124A and 5, and the proposed reinstatement of the adjective substantiated in section 114 of the Act, which we support, and the deletion of Part B of the register. So these are the issues that were raised, and this is how we responded as a department to such issues. We must indicate, Honorable Chair, Honorable Members, that as a department, we have addressed such a shortcoming with regard to delay in terms of section 125 of the Act by giving effect to its proper implementation. The challenge was more on the implementation of section 125, which has since taken place. The backlog has since been cleared, and the results are now available immediately. You just send your ID number, it's entered there, you get your result within the twinkling of an eye. So the system is now automated, and the child protection organizations and the provinces can now access the information. So there is no delay anymore in that aspect. The issue of the that is much simpler. That is the much simpler method, where there is a need for deletion of Part B of the register and moving it to SAPS. We arrived as a department at a conclusion that it should not support this view, because SAPS records are only limited to convictions, whereas Part B records of the department include both convictions and records of various fora. For example, a case of abuse that is dealt with in a disciplinary proceeding or civil courts will not automatically be available in the South African Police Service Criminal Records Center. So the information, in other words, that is in Part B of the register goes beyond what SAPS has. So it is not easy to just move it there. So the department does not support the deletion of Part B of the register for reasons that we have just advanced. So the proposed amendment of section 120 for A and 5. So the department in this issue does not support the proposed amendment of section 120 to include sexual offenses and persons convicted of the specified offenses, persons convicted in foreign places of safety who must be deemed unsuitable to work with children. Section 20 of the, this is because Section 20 of the Act already caters for the proposed amendment by the Center for Child Law. The issue of attempts will be dealt with by the private members bill that we advised, that was before the Parliament when this was dealt with, and we did not want to duplicate the laws because the principle is very clear that Parliament is expected to be aware of existing laws, so we cannot have two laws referring to the same thing. Otherwise, we'll create confusion. And further than that, from a legal point of view, it is understood that attempt is a crime on its own. So if a person is convicted of attempted murder, attempted rape, attempted assault, and all that, still that will reflect as a criminal conviction. There is no point of adding attempts to this particular case. The proposed reinstatement of the adjective substantiated in section 114 of the Act is supported, and the proposed amendment of the adjective is affected, as will be demonstrated in the metrics that we will go through as part of our presentation, and the deletion of Part B of the register, as we have indicated earlier, because it was the inclusion of the Part B in the SAPS, and also the deletion as a standalone, which we said we don't support. The deletion as the SAPS records are insufficient, as we have indicated in our previous slide, 2, 3 previous slides. So the department does not support the deletion, as has been indicated earlier. So one of the key issues was that was raised by Jelly Beans on the intersectoral implementation of the Act. Failure of the child protection system in South Africa to work as a collective across all players in the system, including government and civil society, and the indication that the bill omits NPOs and civil society as role players in the provision of child protection services. So these are the key issues that were raised by Jelly Beans, and we have responded in the manner that we don't support what Jelly Beans is referring to, because the National Child Care and Protection Policy of 2019 is already making provision for this. And further than that, the department refutes that the policy is failing to promote intersectoral work across various sectors, because the nature of the work of the department is exactly that. It is an intersectoral kind of work. It is more involving of other stakeholders, and it is happening in that way. So it is not clear as to what exactly that is failing per se, but in an overall, we understand that the department is working tirelessly with all the role players. So we do not accept that view. The issue of the role of organization in the provision of child care protection services, which is in terms of Section 5 of the Children's Act. We must also understand that Section 107 of the Act does designate civil society organizations, contrary to what Jelly Beans is indicated. If one reads Section 107 of the Act, it does provide for child protection, civil society organizations to deliver child protection services. So Section 105 mandates the department to make funding available to civil society to deliver services. So if it was not inclusive of the civil society organizations, we would not have having such provisions in the Children's Act. So in other words, we do not support the view raised by Jelly Beans. Organizations relating to parental responsibilities and rights, which is another topic that was taken into account. The organizations, as their names, Gary da Silva, Childcare Society, Sonket, Gender Justice, Children in Distress, Center for Child Law, Professor Dikok, Fathers for Justice, Solomon Mondlane, DS South Africa, Koli Machila, Jelly Beans, Children Institute, Commission for Gender Equality, COMSA, House of Traditional Leaders, Professor Hans Geltin, Give a Child a Family, Legal Aid South Africa, Stellenbosch, Stelcare and District Family Services, Childline South Africa, SANCO, and almost all the provinces raised the issue about the parental responsibility and rights. And what are the issues that were raised that we took note of? The 50-50 rule regarding parental rights and responsibility for both biological parents, which was stressed throughout, that each partner in a marriage or in another setup must have such rights on equal basis. The issues of parental alienation, cultural practices, and requirement to pay damages in order to exercise parental responsibilities and rights in terms of Section 21 and the maternal preference. So, starting with the 50-50 rule regarding parental rights and responsibilities for both biological parents, the department does note the proposal that the Act must make it clear that parents, whether married or not, should exercise their responsibilities and rights. However, the department rejects this proposal and contends that it is not always possible and cannot be made a matter of law as in this bill, because some parents may not be fit and proper. Although they are both biological parents, but they may not be all fit and proper. This may also create a lot of challenges when it comes to court processes, say divorce matters and issues of fighting for custody and all that. So if we put it in this legislation, we may be creating a challenge for the courts and in a way usurping their powers, which we are not expected to do as Parliament. If we were to say, let there be 50-50, because there would be nothing to argue about in court. The law would be already in black and white. And these circumstances differ from case to case. And we cannot have a blanket kind of a provision in a legislation and say, let there be 50-50. Let the courts decide when time comes as to who has what share under the circumstances, rather than to put it as a blanket provision here. Furthermore, parenting arrangements and parenting plans may be drafted to address care arrangements between parents whenever there is a need to do so. So that is why we are not in support of this particular issue. So the other issue that we need to take into account is the criminalization of parental alienation. So the department takes note of the proposal regarding criminalization of parental alienation. However, it is not implementable as it is not sound in law, because the definition of abuse includes the act of exposing or subjecting a child to behavior that may harm the child psychologically or emotionally. Inherently, parental alienation, in a sense, is a form of child abuse as defined in the Children's Act, because it is psychologically and emotionally harmful to a child. So if we were to further legislate on that, we would be duplicating that which is already in existence. So the proposal to amend Section 35 to address parental alienation is already categorized in the Act as refusal of access, refusal to exercise parental responsibilities and rights and penalties for offenders. That is why the department is not amenable to the idea that this has to be also taken into legislation and be crafted accordingly. Again, with regard to cultural practices and requirements to pay damages, the department does acknowledge that there are certain conditions and cultural practices that unmarried biological fathers, black fathers in particular, have to fulfill in order to exercise parental responsibilities and rights in terms of Section 21(1). So these include paying of the damages. So in other words, the matter is already taken care of in terms of the legislation, but the idea is that it is a fact that South Africa is a cosmopolitan country, and we belong to different cultures over and above that, and traditions. And if we were to have a cross-cutting kind of a provision that would make it possible for the non-payment of damages or payment of damages by everyone, it would be very difficult to deal with that. Hence, the department is indicating that in order to remedy this, the amendment of Section 21 is to be effected and replace the word "and" with the word "or" between sections 21, 1, B2, and 3. So we must accept that understanding that, yes, when it comes to issues of tradition, customs, and all that, we may differ as there are unique cases in the country due to the nature of the country South Africa is. This will also allow fathers who meet either of the 3 requirements as indicated in Section 21 to exercise parental responsibilities and rights. So the department is indicating that it does acknowledge this, but it does need to be circumspect in terms of how to deal with this particular issue, taking into account the cosmopolitan nature of the country and the difference in the communities in terms of applying these issues. The issue of maternal preference, the department agrees with the proposal to amend Section 21 to insert a new provision that allows the biological father who satisfies Section 21 conditions to acquire parental responsibilities and rights in the event of the death, incapacitation, or disappearance of the mother. So this would address the perceived issue of the department is in agreement with this particular amendment that has been proposed. We will be indicating or showing in the metrics how we have dealt with that. And the other issue is about organizations that present on abandonment, the issue of abandonment. That is CCL, being the Center for Child Law, Children's Institute, Stelcare, Stellenbosch, and District Family Services. And the issues they raised with regard to that is the minimum allowable age of a person to enter marriage, which is 18 years, regardless of the sex of the person, missed the opportunity to define child and forced marriages within the context of South Africa. The protection mechanism in the Children's Act should include the prevention of children from entering marriage, and also the issue of harmonization of legislation, that is Children's Act, the Marriage Act, the Recognition of Customary Marriages Act, and Civil Unions Act, and all such other related pieces of legislation that refer to marriages in South Africa. So the commentary was around that. The issue of 18 years, that is the inclusion of provision to provide for mandatory reporting obligations of suspected forced marriages by relevant persons, such as teachers, social workers, and GSD accepts this view and supports this view that there must be that kind of an alarm. We should believe that it is already taking place. That's how we get to know about this information from time to time. Otherwise, if it was not for that kind of an alarm, we would not be able to hear of such stories. And then again, no child can be given away into a child marriage. Yes, we agree with regards to this. That a child cannot be given away to marriage. That must be a criminal offense because the Act does need to provide that a person must be of age 18 and above in order to consent to marriage. And any person who does something contrary to that will be creating or committing an offense. And DSD supports this view because the purpose of this amendment is also to ensure that only persons of 18 and above can be regarded as fit for marriage purposes. Protection mechanisms in the Children's Act ambit should include the prevention of children from entering marriage. So the department supports the amendment of section 12.2 to include minimum age of consent to marriage to be 18 years without exception. We were also consulted with the Department of Home Affairs at the time, because in terms of the Marriage Act of South Africa, the commissioner may give consent where parents don't, where children are under the age of 18. So we are requesting the removal of that particular provision, that the consent can be given by the the commissioner at Home Affairs. So the person must be of the age of 18 and above in order to be in the marriage. The issue of harmonization of legislation, that is Children's Act, Marriage Act, and the recognition of customary marriages act and civil unions. Yes, we do accept, as we indicated before, that DSD supports this view of harmonization, but only to the extent that it relates to marriages, because there is another challenge with regard to pieces of legislation that have got different capacities in terms of age. So we won't be tampering with that, but with regard to marriages, yes, there must be harmonization with regard to these pieces of legislation. So the organizations that presented on surrogacy, Professor Ann Skelton and Center for Child Law, they raised an issue that commissioning parents, around commissioning parents and surrogate motherhood agreements. And the proposal was that there must be a replacement of the word commissioning with intending, and the phrase surrogate motherhood with surrogacy agreement, which are used internationally. And as a department, we agreed that yes, we need to align our terminology with the international terminology. So we accepted the proposal. There was also an issue around corporal punishment, that is organizations that raised concerns around corporal punishment, and Skelton, Mtongeni Family Tree, Sonke Justice, Center for Child Law, Stelcare, Stellenbosch, and District Family Services, Save the Children South Africa, Children in Distress, Children's Institute, Jelly Beans, World Vision South Africa, and South Africa National Child Rights Coalition. So these organizations, they raised an issue, one around the insertion of a new definition of corporal punishment, the insertion of a new subsection 11 under section 12 of the Act to make provisions for the ban of corporal punishment. And as the department, we are saying we do not support this view, as it may have unintended consequences. We are, however, saying as DSD, it will be prudent for us to include the guidelines that regulate the issue of positive parenting and such related matters, rather than to have the proposed issues. For example, if we were to insert a definition of corporal punishment, we would be going against the rules for legislating. because corporal punishment is corporal punishment in its ordinary course of business. In order to define anything in legislation, it must either be limiting the ordinary definition or extending the ordinary definition and the likes. So if we are defining a word that carries its ordinary meaning in the same, with the same definition that is in the dictionary, it does not serve purpose in legislation. So we cannot define this word as a department. And further than that, we will be creating a false impression. We'll be creating a false impression if we're to ban corporal punishment in our legislation, because corporal punishment is already outlawed in the country. We must remember the Constitutional Court judgment that dealt with the matter of reasonable chastisement in the country, which reasonable chastisement was a defense mechanism for any person who admonishes a child. But now reasonable chastisement has, in terms of the Constitutional Court judgment, been outlawed in the Republic of South Africa. So by virtue of it having been outlawed, it means corporal punishment then is automatically outlawed. So there is no reason for us, when there's a Constitutional Court judgment that has outlawed reasonable chastisement, to also ban corporal punishment in the Children's Act. We must take note that, yes, with regards to the South African Schools Act, this provision is there that talks to the prohibition of corporal punishment at schools. It's because that particular legislation was drafted before the passing of this particular judgment. So it is a provision that is meaningless in any way. So in other words, corporal punishment is regarded as assault. It's already a common law crime. Anyone who punishes a child who beats up a child is already committing a crime of assault, depending on the gravity of that. It was even the nature of the case that went to Constitutional Court. The parent was saying he was just disciplining a child, but the Constitutional Court understood the discipline to be more than just disciplining a child, but going beyond that, and was regarded as too severe for the punishment of a child. So in other words, if we were to define corporal punishment, we would be creating a false impression that only corporal punishment is outlawed, whereas even the most minor or insignificant beating of a child is also outlawed and is classified as assault in the country. And as we indicated, we are able to provide guidelines for positive parenting and all that. And we must also take into account that if we were to take the judgment of the Constitutional Court and transcribe it into legislation, we would be doing something that is not acceptable, because the duty of Parliament is not to rewrite the law, as it is expected to be aware of existing laws. The law, in terms of common law, it already exists. That reasonable chastisement is no longer part of our law in the country. Therefore, corporal punishment automatically falls by the roadside. So there are exceptional rules where we can amend the common law, but unfortunately, by means of legislation. But unfortunately, this is not one of those circumstances, because this is a Constitutional Court judgment, which we cannot just amend by this particular legislation. Again, the issue of Section 12, which is indicated, so the proposal to amend Section 12 is not supported by the department for reasons that we have just advanced as a department. Organizations that presented on unaccompanied minors. Legal Aid South Africa presented, Center for Child Laws, Brini and COMSA are the organizations that commented on that. There was a need for the inclusion of birth registration and documentation in the bill, and the department does not support this particular view because the registration of birth is already contemplated in the Birth and Death Registration Act, and the Department of Home Affairs is the responsible department to deal with it. Again, it goes with that principle that I alluded to say we can't be duplicating the laws. Everything that has got to do with the registration of pets and all that is the prerogative of the Department of Home Affairs, not of this particular department. And these laws, when they apply, are read together from a normal point of view. The issue around the filming publication of information to children, Jelly Beans, Center for Child Law, Children's Institute, Professor Skelton, the deletion of Section 3 and reinstatement of Clause 32 in the bill. That is the issue that was raised. So the department does not support the deletion of Clause 3. Clause 3 seeks to insert a new Section 6 capital A, which will provide for the protection of children's rights to privacy and information. But the department does support the reinstatement of Clause 32 of the bill. But we must take into account that with regards to issues of privacy and rights of children and information, there are so many laws that are already in existence and that have been passed, like the Films and Publications bill that became law parallel to the development of this particular legislation, the PROPIA, which also got to come into force late last year, and all such related pieces of legislation which deal with issues of protection of information and privacy. So it is not necessary for us to duplicate same as these laws, as we have indicated, that they must coexist and be read together side by side. And we must also take into account that if children were to appear before the courts, the magistrates would also have discretion in terms of what needs to be publicized and what cannot be publicized, and that will be an application within an application during the hearing itself, and that will be determined at that stage. So if we were to include it here, it would also be in a way usurping the powers of the courts, of the magistrates. The issue of disability, Center for Child Law, Jelly Beans, Western Cape Forum for Intellectual Disability and Equal Qualification Center, they raised an issue around the definition of disability. The department supports the proposal to include the definition of disability, but it is also problematic in the sense that we've got different types of disabilities, so we have to take into account that a definition that is really all-inclusive, which is very much difficult to coin, is dealt with, but we agree to that proposal. So again, the issue of intersex that was raised by one of the people who commented during the time, the clause which is in the bill provides for the prohibition of all forms of genital mutilation. We do have a provision in the bill, but we do understand that there was a need to separate between the two. of which the understanding of the department was that the issues of intersex surgical operations and all that fall within the ambit of genital mutilation, because the provision does not say prohibition of genital mutilation, but all forms. We must understand that there is a case that got to be passed in Colombia, which was about unrestricted rights to give consent for cosmetic genital surgeries performed on intersex children, which effectively restricted what can be done to children too young to give informed consent. The question might be, but how is this case related to us in South Africa? We must take into account that Section 39 of the Constitution does provide for the recognition of or consideration of foreign law in an event where there is a need to do so. Section 39 of the Constitution provides that when interpreting any right in the Bill of Rights, every court, forum, or tribunal may consider foreign law and must consider international law. So this falls within the scope of foreign law. We may need to consider this case in applying our minds as a department in treading in this particular space, because it is a very complicated space to legislate on. We will always be guided by the Parliament in this regard, because the challenge with this particular issue is that you have a number of instances where there is a difference of opinion. In the journals that we viewed, you find a situation where a child is not comfortable with the fact that he or she was operated to be a particular gender. A child, when he or she grows up, in terms of those testimonies, one of the children gave a testimony that says, I should have been raised as a boy. That is how she felt at the end of the day. And the other one said, I should have been raised as a girl. And the other one would say, I should not have been raised either as a boy or as a girl. And how do you deal with this particular situation at a later stage in life? Because there was this kind of an operation that happened to this particular child. So it is quite a dicey situation. And in this case, it is a situation where a parent had to take the hospital to court for operating a child who was 16 months at a time. But what is key is that the parent won. But the child neither gave the consent nor the parent gave the consent that the child be treated in this particular fashion. So that is why we may need to look at this particular case and apply our minds as the department, and also be able to deal with this particular issue. So it is quite a challenge, because we don't know what the child would raise later in life in terms of whether the operation was correct or was incorrect, or it favored him or it did not favor him. So that is why we had to cite this particular case. And as we said, while the ruling does not directly affect intersex people in other countries, as it was stated, including South Africa, but it does show that it is possible to change the medical practice through legal advocacy, which is what we need to look into. And it also assists South Africa to learn from what other countries are saying about this matter. And as I indicated, that yes, we have all the powers to do so, because Section 39 of the Constitution does provide for that. and several rights that get to be affected, because in case somebody asks, but there are no rights that are affected, but the Constitution does provide for the rights, like the right to life, the right to privacy. These are the rights that are likely to be affected when the surgical operation takes place. So there is also the issue of prohibition against torture, a right to physical integrity or bodily autonomy. And what is very key, again, is that the best interest of the child to be taken into account in this regard. But sometimes it is a very difficult terminology to deal with because the child is not involved at this stage, and we don't know what the child wants because it is still at a very early stage. So in this particular case, I mean, there was an award, a financial award, meaning that the hospital itself had lost the case and the parents were made. But this is what I've been trying to explain in the previous slides, that yes, the case was successful and the hospital had to pay the parents for this kind of an issue. Again, with regards to the ECD sector and the issues that were raised, the Director General, in his opening remarks, which he put forward for the department, ECD is moving in the next fortnight. It will no longer be part of the Department of Social Development. So all the comments that were made for ECD are part of the Children's Second Amendment Bill, which the typical team, inclusive of the sector and the Department of Basic Education, have been dealing with. So we stand to be advised by your good selves, Honorable Chair, and honorable members in terms of this particular issue, because it would not make sense for us to take note of these comments in terms of entertaining them, because in the next 15 days, they won't apply to DSD anyway. They will be applying to DBE. So these, they related to funding of childcare facilities, the childcare facilities such as the ECDs and drop-in centers. So they only, these comments only relate to us when it comes to drop-in centers, CYCCs, and partial care facilities who apply for funding and all that, but not with regard to ECDs. So we must also take into account that funding gets to be allocated at provincial level and also in the national sphere if the organization is represented countrywide. So what we may take into account when it comes to drop-in centers and other centers like those, like your CYCCs and all that. The first issue with regards to funding of these is the question of must versus may, because the bill has been saying the HODs or the MECs may, from monies appropriated by the legislature for that purpose, provide funding for ECD or child care centers or drop-in centers and all that. And the issue was that no, we must not say may, we must say must. And unfortunately, we don't accept that proposal because it is very disastrous financially. We don't know how many NGOs are out there, how many applicants are out there, how many other NGOs are still incoming into, as we are registering NPOs on a daily basis in the department. If we're to say must provide funding, we may be litigated for using such a word when our budget does not necessarily speak to that. So as a department, we reject the use of the word must in favor of the word may, depending on the circumstances. Again, the issue of municipality bylaws. We did speak about intersectoral issues in the beginning, where we said the challenge that we have with regard to the provision of our services is intersectorality. Is what we also find in this space with regard to the municipalities, because municipalities have got a role when it comes to implementation of bylaws. If a person wants to register a child care facility or something like that, a drop-in center, a youth care center, it is very difficult to have an application approved because the municipal bylaws that speak to zoning and rezoning make it a little bit problematic for the implementation of such bylaws or what the person wants to do. So we are saying the issue of streamlined registration must also take into account the existence of the bylaws that we have in the country and all the other corresponding issues that need to be taken into account. So the funding is provided for fully registered and conditionally registered facilities, as is the case with regard to the Children's Act. So the ECD sector issues that we raised, it is important to just take note of the issues that we raised. That is the plight of children in the child-headed households, the children in child-headed households are dealt with in terms of Section 137 of the Act. So this is already provided for, and such households and cases must be referred to the area social worker for assessment, intervention, and formal recognition by the provincial head of social development. So what we are agreeing to in this regard, that in fact we are acknowledging the existence of the plight of the child-headed households, and also the issue of the existence of the provisions in the Act that already deal with this. So we already have, as the department, many children in the child-headed households who are placed in the foster care system to ensure that they are safe and their well-being is taken care of. So this must be understood in that context. And the issues that were also raised around the child household, the Department of Social Development, that is shortage of social workers and issues raised. Okay, the Department of Social Development, in partnership and collaboration with other sector departments and some entities, has developed a draft sector strategy for employment of social work professionals, which is inclusive of social work occupational category. The department is currently consulting the draft sector strategy with the critical stakeholders. The department does accept the shortage, as been indicated by the DG in his opening remarks. We do acknowledge as a department that we've got a challenge. Out of the social workers that exist in the country, which are about over 30,000 in number, 17,500 belong to the sector. And we must take into account, Honorable Chair and Honorable Members, that when this bill or when the Children's Act was presented in the latter part of the beginning of the millennium, about 2007 or 8 or so, there was a study that was conducted by Cornerstone, which indicated that in order to implement effectively the Children's Act, the department needs about 67,000 to 70,000 social workers. and we don't have that number in the country altogether. So everything that we need to do, we are trying to do the best out of the little we have. And we still share these social workers with various other programs, because it's only 67,000 for the implementation of the Children's Act. And according to the study that was conducted recently by the Department of Labor, we also need about 5,000 plus for the implementation of substance abuse legislation, about close to 2,000 for the implementation of the Older Persons Act, and also a number that is still to be determined for the implementation of the Victim Support Services Bill, which is the Gender-Based Violence Bill, which is still coming before you in the next few months. So we need to take all that into account, that some of the gaps that may have been identified or raised during the hearings may also be because of the number of the social workers that we have in the country. I think the DG has said it enough. I don't want to spoil that which he said, but just adding that voice. And the capacity assessment report on availability of posts across sector departments has also been developed, which gives an indication of the field vacancies and the vacant funded posts within the organizations and the structures. The shortage of social workers, again, the issues that we raised, the employment of social workers in schools, also take into account what we have just presented about the shortage, and the Department of Basic Education forms part of the intersectoral forum, which guides and leads the development of the draft sector strategy for employment of social workers. So there is too much competition in the space in terms of every organ of state is looking for social workers, and we've got very little that we have as the stock that is available as per the council's records. The general issues that were raised, the family reunification services is one of those. As soon as the child is placed in alternative care, the social service professionals should start having sessions with the family to rehabilitate them in preparation for reunification. This is very much important because, yes, we do acknowledge, Honorable Chair and Honorable Members, the challenge that we are facing around this particular issue, that a child reaches the age of 18 and there is no reunification or reintegration process that is in place. And now we've got that gap between finding a proper family and the child leaving the institution, the child in which he or she was placed. So the department then is I urged to strengthen families to be able to care and protect their family members through the implementation of a reunification care plan and permanency plan. So the department is asked to plan, implement, and monitor the reunification process to ensure the success of reunifying members with their families of origin. Regular contact will be established and maintained. So these are basically the issues that have been raised, and that social workers do not monitor foster care placements regularly. DSD does acknowledge that the shortage of social workers contributes to the poor monitoring of foster care cases. That is acknowledged, and the department is working on that. But it does not necessarily relate to the amendment of any provision in the bill. However, other social service practitioners are also empowered by the Children's Act to monitor placements, which at least creates a leeway with regard to such issues that are raised. I think in this particular case, Honorable Chair, we can just ask your indulgence in terms of whether we take questions or we move to the matrix. Thank you for now.
Yeah, no, thanks, Leander. So, Chair, we're in your hands in terms of how you suggest we should move in this regard. Thank you.
Come closer to the mic, DG. We can't hear you.
Sorry, Chair, I was saying we're in your hands in terms of how you would suggest we move. We're in your hands, Honorable Chair. Thank you.
Thank you much. We never thought that it would be so long, but I hope that the honorable members have noted their questions. Yes. Can we then go to questions, honorable members? I can see the hands of Honorable Vandameve, Honorable Masango, followed by Honorable Gizela and Honorable Alex. The last one, it's Honorable Aris. Thank you very much. Can we follow that sequence?
Thank you very much, Chairperson, for the opportunity. Let me firstly say that we wish the DM well, and we wish to align ourselves with the comments that you made and the ADG in appreciating the work of our social workers. We also thank the Minister for her opening remarks and this very long and extensive presentation. I've got a couple of questions, and it was a very long presentation, so I'm not sure whether all of us will get to all of the questions that we've got. But let me start off by firstly asking the department, why is it not supporting the proposal for a traditional clause to protect existing orphans on the foster care grant from losing their grant? Just clarity in that regard. With regard to the rights of fathers, I don't believe that we've done justice to this issue, Chairperson. And I would like to ask the department, how are they planning to address, because it's not in this presentation, the issue that was raised very vociferously by fathers about the issue of parental alienation, which in itself is a form of abuse. So what specific corrective action have they proposed? Because I think the presentation is silent on it. On the issue of 50-50 access to children, often we find that, and it was raised, that men and fathers have to prove that they are fit parents, whereas women don't have to go through the same lengths to do that. So often the onus is on men to prove that they're fit parents, whereas women don't have to do the same. Again, what corrective measures have they proposed to ensure that the 50-50 access in terms of contact and care is entrenched, upheld, and respected? Then with regards to section 105, 107, and 167 as it pertains to the safe child abandonment. Chair, the child protection services currently that are rendered for abandonment are not preventative of the act of abandonment, but it only steps in once a child is found alive after being safely abandoned. So we urgently need to ensure that child protection services prevent the act of unsafe abandonment, and therefore we need to ensure the safety of our children. The Minister spoke about all of us needing to put our children first. So I would like to ask, why is the presentation silent on abandonment and the need to legalize baby savers? It was an issue that was raised. We had presentations on this issue, and I don't think we can continue to criminalize women or mothers who wanting to safely abandon their babies. Many other countries have decriminalized this. So I think I would like to ask, also I want to make the point that a baby saver is not alternative care. So a baby saver is not a mechanism used to save the child from unsafe abandonment. And so therefore a baby saver cannot qualify as alternative care in terms of section 167 of the Act. So my question then becomes, would the department agree that we need to still further amend or have additional clauses that would make the safe abandonment of a child, to legalize the safe abandonment of children? And if not, why not? And I think maybe if the department doesn't agree that we need further amendments in this regard, then maybe we should consult our parliamentary legal advisor to give us guidance in this regard. Now, on the issue of adoption, it's something that I'm very passionate about. Now, in this presentation, we keep on talking about the fact that there's a lack of social workers in the country, and it's something that we as a committee have addressed on numerous occasions. For example, there's the presenter just said we don't have enough social workers in the country to implement the Children's Act, for example. But now, on the flip side, the department says it wants to manage adoptions in-house in slide 18. But again, we need to address the question about how is the department planning to take over all adoptions, considering that we do not have enough social workers? How will it have the capacity, considering that social workers are already overburdened? And remember, we wanted to free up some social workers to attend to the issues of foster care and child protection services in particular. So ADD said that they are actively engaging Treasury for more money to employ social workers. But the current situation is that we don't have enough social workers. So this will actually just worsen the situation if we try to take all adoptions in-house. Now, again, I want to speak on the issue of the link between trafficking and adoptions. We have consistently asked the department for proof that there is in fact a link that national and international adoption of children is being used for child trafficking. We have also asked that they provide us with proof that service providers are charging exorbitant fees when they do adoption, but none of this has been forthcoming. And when I submitted a written question to the department, the minister replied by saying that they're not aware of a link between child trafficking and adoption. And the minister replied that there is no record of any trafficking having occurred through adoption. So I hear the arguments that are being put forward in terms of Russian and Chinese examples, the Hague Convention, the John Seabrook and David Smolin work. But the fact of the matter is we do not have proof that in South Africa there are any link between trafficking and international adoption. And what is more concerning is I believe that there's only been 250 inter-country adoptions since 2010. So that's a very low number. So my question then is, why does the Department of Social Development think that removing Section 249 and making adoption in-house, that it will actually prevent trafficking? Because like I said, there's currently no link and evidence to suggest that that is the case. And remember, our laws and our processes have checks and balances. That is exactly what the international treaty requires. So South Africa meet these standards. Our private adoption agencies do comply with the laws. So, you know, at the end of the day, also what is concerning is I believe at universities, social workers are not trained on adoption. They get an introductory information on social work. So they're also not trained in terms of doing adoptions. It's basic information on adoption and not specialized training. So really, I think the department must take us into confidence as to what are the real reasons. Why are they trying to break something that's not broken? That is my question, because at the end of the day, if there's no evidence to suggest that the way we are currently doing adoptions is causing mass trafficking or harm of our children, then what can they take us into confidence? Because I think we're really trying to break something that is not broken. And lastly, Chairperson, I would like to I know we've got many other questions that must still be asked, but I would also like to ask, just in terms of the section which I think is going to be problematic, the section 249. Now, of course, removing that entire section, you know, I maintain that it will have unintended consequences, because with this proposal, you're effectively opening the door for unscrupulous individuals to profit from adoption. Because currently the Children Act says no person may give or receive or agree to give or receive cash or in kind, any consideration in cash or kind for the adoption of a child. So if you remove that entire section, there's no, that protection, deleting that clause will actually possibly inadvertently facilitate the sale of a child. So why, if the problem is with the issue of fees, why are we not just deleting the section that refers to fees instead of deleting the entire section? And maybe we should also, if we can't agree on this, get a legal opinion in this regard. And yeah, my last question, section 2391D, when we say now that we will make sure that it says that we will in 30 days make sure that letters are issued, that we will solve the problem of the delays. But however, there are no consequences added if provincial heads fail to comply with this in terms of issuing the letters within 30 days. So what consequences can we still build into this amendment bill in this regard? If I can just get some views on that. Thank you, Chairperson.
Thank you very much. The next one I said it's Honorable Masango.
Thank you, Chair. I just also want to wish the Deputy Minister a speedy recovery and assure the Deputy Minister that she is in our prayers, and also wish a happy worldwide World Social Workers, Social Practitioners Day to our social workers, who are today actually a huge issue in what we are trying to deal with. But I also want to thank the department for this presentation, because it has really delved into issues, and I didn't hear what the chair said about the matrix, as it were, but one believes that this presentation has in a way covered some of the ground, although one would actually be very happy to hear what what the department had to have benefit of the matrix as has been done in a way that it has been done, because it is really, really helpful. It was helpful to even go through the presentation and the matrix. Chairperson, the questions that have been asked by Honorable Van der Merwe actually cover most of the questions that I would have liked to ask. So I will benefit from the responses there too. The question that I would like to ask is the decline in number of adoptions and the need for adoptions, because the department has only focused on a decline in inter-country adoption from my reading of the presentation, which also says to me that the reasons that have been cited for the decline is focused on domestic possibilities and family first, about children who are abandoned and whose parents cannot be traced. One would want for us to hear what the response of the department is in cases of children that do not have family, like the children that are being abandoned, because also one has to take into consideration that the amendment bill has to deal and grapple with the issues that are happening in South Africa. And so one, for me, we need to separate between inter-country and national adoptions. And two, we need to take the context within which South Africa is in at the moment, as opposed to quoting what is happening in other countries in different contexts and different events that they are dealing with. For example, the issue of abandonment is huge when you want to say that we need to consider family first, because an abandoned child, by definition, does not have a family to consider first. And so when we do what we do, one would like to know how has that been filtered into the responses that the department has put forward. And so also it is a bit concerning to hear that the department is saying that adoption is a last resort. That means that the institutional care or care in impermanent foster care with unrelated people are preferred to adoption. Are we going to try to get impermanent placement for children, permanent adoption, if we are saying that adoption is a last resort. And Chairperson, when I was listening to the presentation also, Mr. Leander was saying that there is research, and then he quoted the writings that he quoted by the two people. But I still would like for us, because it's a huge decision to take, to do something like what we are trying to do here, without any research, without any statistics. I still would like to those research documents to be shared with us as we get into the formal stage of processing this bill. And also, Chairperson, the issue of using Russia as argument for having changed their law, I believe that we should, because this is for me, although we are signatories of international treaties and things, but there are issues that are uniquely South African. And if we are saying that we are going to also, are we saying that we are also now changing the law based on the fact that Russia said that Russia's children must be raised in Russia? Are we saying South Africa's children must be raised in South Africa, regardless of the challenges that we are facing as a country? I just was a bit concerned that we are saying that other countries change their laws, so we're changing ours, because I did not hear any argument that is based on our situation in South Africa. And also, I think the presentation did touch on the fact that I did not hear or see in any of the presentations by So I appreciated the Mr. Leander's presentation to mean that that is what it was interpreted as, because I didn't hear any of the organization saying that. And of course, I have talked about the temporary safe care, excluding abandoned children, which I would like us to bring back into the discussion and eventually into the decision of what stays and not stay in the bill, as it were. And so, Chairperson, those are the questions I have for now. And I believe that we will need to have more time, especially with the matrix, where one can raise issues as we go along. But thank you so much, Chair.
Thank you, Honorable Masango. Honorable Kiza.
Thank you, Chairperson. Good morning, colleagues. I have been covered by both the previous two speakers. I just have some questions for clarification then, Chairperson. On the issue of the capacity assessment report, we all now know that we need 70,000 social workers to implement the Children's Act. We only have 17,500. Last year, we had 9,000 unemployed graduates, and DSD only hired 3,465 of those. So you mentioned other social service practitioners. I'd like to know how many other social service practitioners do we have to stem this big shortfall or shortage of social workers in the country. Then also regarding the declining numbers of the adoptions, Honorable Masango already spoke on the national versus the international adoptions. I'd like to know, are there maybe a monetary reason for the decline in adoptions? For example, when when you adopt in South Africa, do you still qualify for grants like in the case of the foster care? I just like to know that. And how many national adoptions did departmental social workers close last year? Then regarding the 50-50 biological parental rights, can the amendments then not say 50-50 unless not found fit and proper as and when the courts decide? Because right now the situation in the country is that there's a lot of mothers that are abusing the children's grant, and the fathers don't have the 50-50 rights like the mothers automatically do. And my last question with regards to the funding, you said funding for ECDs are allocated at a provincial level. I'd like to know if it's possible. Can we then have a breakdown of the budget cuts provincially, please? Thank you, Chair.
Thank you, Honorable Kizal, Honorable Alex, followed by Honorable Harris.
Thank you, Chairperson, and good morning to colleagues and the department and everybody else online. Chairperson, I'm echoing what the previous speakers have said, so would like more detailed report back on the issues outlined by the previous speakers. But Chairperson, just to add, you know, in Parliament, we've recently been debating, you know, South Africa's social and economic challenges, the inequality, unemployment, poverty, etc. And all of these make it a very fertile, you know, breeding ground for child exploitation. And now in this act, you know, it centers around child protection. But what we see time and time again is that what is said in our presentations, in committee meetings, and that's written in presentations, and in black and white in the various acts, it does not translate to implementation and impact and improvement on the ground. So we can change acts with the best intentions, Chairperson, but if we, you know, fail to implement, you know, we just back where we started. And, you know, on the issue of the removal of adoption fees, you know, we just need to be so careful that we aren't sidelining the CSOs that are there to help carry this burden on the state. Because we see time and time that our courts and the department is struggling with capacity, and we're getting nowhere. And, you know, children are just becoming more of a commodity in our country. And we see this with the abuse of the child support grants. So, Chairperson, my questions to the department on the issue of the adoption fees, and I hear the presenter saying that nothing's going to change, you know, adoption agencies can still operate. But then does this mean that the department, you know, well, can the department private adoption agencies, will they have access to children in CYCs to assist with adoptions? You know, will DSD still be funding and supporting these agencies? That was provided. You know, we cannot forget that one of the reasons, Chair, am I still audible? Okay, yes, I am.
You are?
Okay, because I just got a message that my internet's unstable. Chair, on the issue of China, we cannot forget that another reason China saw a decline in adoption was that they saw an end of their one-child policy in 2015. And, you know, during that time, while they had their one-child policy, they saw an increase in child abandonment, because if you gave birth to a disabled child, your first child, or sometimes even a girl child, those children would often be abandoned. And I think there's a massive difference between us and China. And one of those big differences is that China is by the financial means to adequately support their orphaned and abandoned children. And here we can barely fund our CYCCs. So, you know, we just need to, when we are going to put up these stats, that each of these countries have their own other, you know, history to it, you know, when looking at this. And, you know, another question to the department is that will the department still be doing the accreditation of adoption agencies? and my colleagues have said before me, we've asked before to please give us a breakdown of these exorbitant adoption fees so that we can see for ourselves, what the department's referencing, because if they're NGOs, the department are auditing their books. So clearly the department is seeing something that we aren't seeing. So by giving us some examples, we can see for ourselves, what the department is speaking about. And then, Chair, I can't read this presentation without also keeping the department's previous presentation in mind. And, there was one line in the previous presentation that said the deletion of section 249 will work to the advantage of mothers and children. And I still would like the department to explain this to me. How is this working to their advantage? And how by removing the fees, we're going to just suddenly stop the illegal sale and trafficking of children? Because I'm of the opinion that if somebody wants to sell their child, they're going to sell their child, whether they do it underground or on the black market. We need to separate the criminality of this child trafficking from the people who are actually trying to assist the state with this. And then, Chair, on the issue of child trafficking, what is DSD doing about street children? They can be easily picked up off the street and exploited. And what is DSD doing about this high number of children without birth certificates? These are all vulnerable children, but we're just focusing on this one aspect of child trafficking. Then, Chairperson, I'm just going through my notes here. Again, we've asked the department for more evidence-based references, and I see that they have cited the 2 references. I've done a quick search and I can only see Seabrook's references from 2010. So I would like the department to please provide us with those references so we can also do our own research. And then on the issue of institutionalization of children, Chairperson, I would like to know if the department, if they've done an audit on our CYCCs, on our bed spacing, on the funding to these CYCCs, because, the provinces are doing their budget votes, and all of the provinces, have taken massive financial cuts. And I'm of the opinion we're only going to see these cuts through our social welfare budgets year and year and year on. So if we are going to say we're keeping the children institutionalized, do we really have funding and capacity to be doing this? Then, Chairperson, I've got lots of other questions, Chairperson, and, we always say we're going to submit our questions in writing, but the department very seldomly gets back to those questions, Chairperson, even though you have okayed it. And, one of the things I'm still waiting for is a status update on the foster care backlogs. Our committee hasn't seen, the recent figures on where we are sitting with the foster care backlogs. And I just would really like to ask the department for that status report again, Chairperson. And then just lastly, I know it's not, in this act, but during the public hearings, the abuse of the child support grant came up quite often. And, I'm of the opinion that this equates to child abuse, using the grant for substances and, all other things. And I just would like to know, or rather plead with the department, to please drive a more visible and aggressive campaign on how to report the abuse of the child support grant. And then lastly, Chairperson, if the speaker can maybe just give us in writing the breakdown of the shortage of social workers per program, which he mentioned verbally. Thank you, Chairperson.
Thank you, Alex. Followed by Honorable Harris and by Jane. Honorable Mangani. Thank you.
Jane, is it my turn?
Yes, you are in.
Oh, okay. Thank you very much, Chairperson. Chair, I just want to check. I'm grateful because I'm covered with most of the things, that the previous speakers were saying. But my thing is, I just want to check. Recently, there was a High Court judgment in terms of parental rights of same-sex parents, which was saying that, when artificial insemination was used, that parents have also equal rights in terms of that. Because now you will have 3 parents, and I want to know how we will deal with that, because you will have the parents of you will have the parents of the artificial insemination was, and you will also have, because the act is just speaking about biological parents. So I want to know what will the rights be, because there will be 3 people involved in that parentalship. Then also the issue of social fathers, and I'm still on that one, because the act is quiet on that one. What is the rights of social fathers? Thank you.
Honorable Jane. Thank you, Honorable Harris.
Thank you, Honorable Chairperson, and greetings to all members. And I also echo what my colleague have said, to wish DM a speedy recovery. And then I must also thank the presenter, because some of the question that we didn't understand more when we were doing public hearing, in his presentation is clearer. So my issue, other members have covered me, but not on the one that I wanted to say, because I believe each and every country need to be proud by its own people, and then make sure that if there's struggling of people, that's why the grants are in. Even although sometimes we feel as if there's nothing. I wanted to comment on the issue of adoption. As government wanted to do the adoption, not alienating other agency, I feel very much strongly that I support one section of this adoption that says we must look around families and around the country first. Why I'm saying this? When even if I compare what used to happen in when I was young, we were adopting people from our country whom we don't know. Today they are our sister, brothers, and then they take care of us sometimes when we have challenges. I feel strongly that maybe we are hitting ourselves hard. We must leave this, we must make sure that this adoption should remain, should be done by our own social worker. I have heard when we were doing a public hearing, there were more voices was from the agency. And then the social worker were very silent there and there. But Mina, I feel very much strongly that I think I align myself with the presenter. And then on this one of father, I think we have to rethink, because a father can't take responsibility only when the mother has passed on. We must come up with something, because fathers really, maybe it's because some of us, we stay around the rural where we can see if a father is denied the right.
One, I mean.
Can you mute yourself, please?
Okay, excuse you.
Thank you, Lindy. I think if we can check, it can't be a father is a father when the mother have passed on. We are having also challenges on the side of women, as much as we are having challenges on the side of men. But we have to make sure that even those who are not married, they can also have the right to their own child. For now, as we are doing this bill or amending, we've been having this challenge of saying people can't take ID because their mothers don't have ID, they don't belong in this country. It's only the father is from this country is South Africa, but they are unable to assist their own child. And then a child grow with that anger that says, my father was not there for me. Let's not aggravate this issue of fathers. We must come up with something. I agree somewhere, somehow, that you can't make them 50-50. Why we don't do something that the country must see that we are one step ahead. We are not stuck on the very same issue that fathers always cry, When we hear, we take them to court to go and pay maintenance every month. Whilst they don't see their child, they see their child's son.
We've lost two meeting. Honorable Mangani. Honorable members, seemingly Honorable Mangani has got a challenge.
I've got a challenge of network.
Okay, finish up so that Honorable Stock can follow.
Yes, I've got a difficult challenge with network.
Yes,
I was just concluding, Chair, to say others. I agree with what my colleague has said, but on this one,
okay. Seemingly, Honorable Mangani is struggling with the network. We will allow her to finish up. Can we allow Honorable Stock to continue?
Thank you very much, Honorable Chairperson. Let me also join my colleagues in appreciating the presentation done to us today by the department. I think it's quite detailed, and then it also clarifies to a large extent the issues that we actually interacted with when we were doing the public hearings throughout the country in the different provinces. So I'm very grateful for the information that comes back in terms of the responses, the issues that were raised as well by different stakeholders throughout the sector. I just want to get clarity from my side. I want to get clarity on the issue of the China and all of that with regard to adoption, the clause on adoption and all of that. If the department can give us more detail in terms of whether there's a case study or in different countries, how this issue has been handled and what is the approach. Is it normally being relegated to the private sector or to the CSOs, or is government that plays an active role in that regard? And then also in terms of adoption, which was also, when I looked at the presentation, was an issue which was bothering me. But when I listened, some of my colleagues actually covered me to a particular extent. But you know, what I want to indicate now to the meeting is that I'm persuaded by what the department was saying in terms of the adoption, that because I think the person who was presenting says to us, we are not looking at removing the whole clause on adoption, but maybe we need to look at the issue of the clause that deals maybe the fee and the fees and all of that. Maybe it's something that we need to look at. And I think it's also an issue which was properly canvassed by Honorable Lisa. So I think I just needed to indicate that I also support that proposal. Thank you very much, Honorable Chair. Thanks.
Thank you, Honorable Stock. Are you back, Honorable Mangani? Not yet. Oh, she's back.
I'm back, Chair.
Finish up? Can you finish up?
Yes, Chair. I was just finishing, just saying the issue of fathers. I think we didn't do justice. We need to reconsider, or we need to have time to talk about it. Because sometimes the course route that we are having, challenges that we are having in the country pertaining children, women, and also fathers. We must do away with the root cause, unlike taking the shortcut of saying, because the court is saying this, but we need to say something as this committee, and then convince each other. Because for now, I'm not yet convinced about the issue of fathers. Thank you, Chair.
Okay. Thank you very much, honorable members. You have also covered me in most of other things, especially in this one of saying, what is exactly the function and the role of the committee if we cannot also add on the amendments that have been put forward? Most of the honorable members have made mention of that. In my knowledge and thinking, we are supposed to be the one who are also adding in these amendments that have been put forward. Because really, I see that if the department is saying to us, nothing they can do about the adoption, what does it mean? Whilst the bus stops at us as social development, and they put and claim that the court or the justice department is this and that particular department is saying this and that. As social development, what is it exactly that we're supposed to do? Can't we say this must happen like this way so as to carry on this amendment forward, rather than to come today by saying most of the challenges that we have and questions that we couldn't answer, we are still unable to answer them, because as social development, there's nothing that we can do. That's my thinking. Maybe when we go clause by clause, even if it's not now, next week, members are able to go back and tease up clauses that they think it needs to also get flesh on it. I think we are free to do that. Otherwise, it was really I will say a brief and clear presentation from Luyanda, which I never expected it will be so long and so brief and also clear as it was put in public hearing. You know, I'm also thinking about the department when they are saying they don't know the NGOs. It means to me there is no database. There is no database at all. They don't have it. And what needs to happen? Who is supposed to have the database for the NGOs in the country? Because it is so simple and straightforward that if they can phone the provinces and get that database from the provinces, ultimately at the end as national, they will have it. I'm also not happy about this 50-50 thing, much as it is saying that the parental responsibilities have been also given to fathers. You know, most of the fathers that were in those public hearings were crying tears as Jane is putting it forward that we will only as women need fathers when we want them to go and pay the support or the maintenance in court, which is not fair. Much as at the same time, even the mothers are also crying tears because of the court judgment that are taking too long, that are also favoring fathers more than the mothers. I go in line with the one of saying 50-50, but this 50-50 needs also to be scrutinized and be teased off on how does it mean or what is it meant when they say 50-50. Those are the things that we have as the committee. It's our responsibility to look at them and come up with something that we want it to appear. There is also this one of the age. You know, this one of the age, I still remember vividly the presentation from the professor, the one that we had in our previous meetings. And seemingly, we still doesn't come up with something that is saying, how about as departments align this thing of the age in terms of the adolescent? How do we categorize a person who is an adult? That thing of 16 years, 14 years, 18 years is still there. And as the department, we never came up with something that we will say, how are we going to approach it to other departments? Because these are sister departments. We cannot move into our corners and cocoons. We have to work together. Those are, I think, are the comments, man, rather than the questions. Because even this one of saying, or Luyanda was saying, I will hear from you, honorable members about the ECDs. The questions won't be our questions for now. After the first, it will be, we have to know what is it that is supposed. That is exactly why we had a joint meeting with DBE, so as to be able to have this integration. We are able also as social development to answer the questions that are being asked from the communities. Now let me stop there, otherwise most of the questions has been asked by members. It's just a comment, and if DG and the team is able to say something on this, I would appreciate that. But I think even in the next meeting, we have to go clause by clause and put what we think as honorable members would like it to appear in this bill. Can I stop there?
Thank you very much, Honorable Chair and Honorable members for the input. Indeed, this was a lengthy presentation. I must just indicate, Chair, that perhaps to Honorable Van Merwe and Honorable Masango on some of the issues that may seem silent in the presentation, I can assure you that these are covered adequately in the matrix, and hence we had sought guidance to determine whether we should go into that detail or not. But I can assure you that these matters are indeed covered in the matrix. And then I wanted to indicate, Honorable Chair, I suppose when Leandro was speaking about the NGOs, he was not knowing the NGOs. He was talking more about the fact that NGOs are emerging on a daily basis, and that we do, as a matter of principle, have a database of NGOs. But sometimes when it comes to the funding aspect, we may not know which one needs support and so on, unless they come up and say that they need the support from us. But indeed, I can confirm that we have the list of NGOs. We are the custodian of NGOs as the Department of Social Development. We register them, and therefore we keep record accordingly in that regard. And then just on the ECD question, Chair, indeed, I think that...
excuse me, TG. I can see that Honorable Stock's hand is up. Maybe he's going to come up on how do we go forward with this. Can we give him a chance before you just summarize everything? I can hear that you are just summarizing all the questions that we asked. Over to you, Honorable Stock.
Thank you very much, Honorable Chairperson. And I'm so sorry to do this because, I mean, it's like I'm coming in the tail end. The department was supposed to respond, and then it looks like it's an afterthought. It's just something that slipped my mind. I noted it down, and I was supposed to raise it as part of my submission. So I need to profusely apologize for the approach that I'm taking. I just want
you are welcome.
Okay, Slalo. Okay, I just wanted to propose to the meeting that in terms of the matrix is quite detailed. I think it's about 88 pages or so. So I was going to propose that because we are not at the stages of the clause by clause, then maybe we must agree in the meeting as a portfolio committee that the department must come back. When they come back next week, then we deal with the issue of clause by clause and then the details of the matrix. And then it will also give us an opportunity as honorable members to also acclimatize ourselves with the details of the matrix. That's what I wanted to propose, Honorable Chairperson. Thank you.
Thank you very much, Honorable Stock. I knew that you are going to come up with on how to go forward, rather than acting DG to just summarize and, all what we were asking and concern, but preferable DG without even answering most of this. I thought you would just have a comment on what we are suggesting, that how about dealing with clause by clause in the next meeting. And the matrix, as the Honorable Stock has said, for next meeting. Can you just go to that?
Sorry for interjection, Chair. Members Van der Merwe's hand is up. I don't know whether she wants to comment before the DG. DG.
Over to you, Honorable Lise.
Thank you very much, Chairperson. I just wanted to make an appeal because it was quite a lengthy presentation and some of us forgot some of the questions that we wanted to ask. And taking from what you have just suggested, that when we get to the clause by clause process, that you would want us to make our input as a committee in terms of what we want to see from the amendments, would you allow us to submit some written questions, Chairperson, that we forgot to ask, and maybe then ask the department to get those back to us before we do the clause by clause and the matrix? That is my appeal, so that we don't delay the meeting.
Okay, is always the Honorable Lizelle accepted for members to write questions to the department via the secretary? So no one will be stopped by asking questions. I understand, as I have said before, that this presentation was too long. I never even expected it will be so long, but nevertheless, it's not closed. Doors are always open for the department, from the department and from our side to communicate with them.
Thank you very much, Chairperson.
Can LinkedIn DG respond on, or comment, not respond as such, but comment on this one that we are suggesting on the process on how to go about?
No, thank you very much, Honorable Chair and Honorable Members. Okay, so there are two approaches we could take, Chairperson, and I'm in your hands in terms of how you suggest we move. One is to take the, well, firstly, if we are to respond to the questions raised in the meeting today, we estimate that we can take about 30 minutes, just at a high level, responding to all of the specific questions asked today. We could do that. But I agree that in line with Honorable Stock's proposal, that maybe we could set another day where we go through all the clause by clause. We'd be happy to do that. We would, however, suggest that that should take an entire day of the committee because it's quite lengthy, as Honorable Chair would have seen. But we're happy to do that. But I think that in terms of the questions, we would certainly be able to respond to those raised today in the next 30 minutes or so. We would be happy to take that, Chairperson. And then come back at the time that the committee would advise to go clause by clause. We're prepared for that, even today. So if the committee has to say, let's go, now we'd be able to go clause by clause, because we have prepared adequately for that. But we're happy to take another session. We would go clause by clause as suggested by Honorable Stock, but we would then recommend to the committee that perhaps it be a full day in that regard. But thank you very much, Honorable Chair. If the Chair wishes that we respond to the questions raised today, I can guarantee you it won't take us longer than 30 minutes in time to get through some of those. Thank you very much, Chair.
Okay, thank you very much, Gigi, but I don't think it's going to assist for you to answer the questions rather than to go to this exercise that we're talking about. In my thinking, I don't think it will be all the clauses, but there are critical clauses which we think we have to have a bite and say something on them. But if it goes to that push, we need a day, then we can look for a day and set aside for that day to look at that. Otherwise, the bill is not a once-off thing. It's really something that we have to build on and make up our minds and be collected, because it's going to be life for the entire communities and for the rest of our lives until it is amended again. So in this this term, we have to say there is a legacy that we have left. At least we have tried our level best to amend it as such. I don't think it's a train smash of not saying that. How about looking for that particular day? If we haven't finished on that day, which is, we can even extend the time for our start so that we can be able to cover up a lot of ground on that day. We'll definitely look at the dates, and Lindy is going to communicate with you and tell you on which day do we think. The ones that are supposed to submit the questions, the written questions, it will also assist us, even yourselves as the department, to prepare those clauses that we think. Those honorable members that think they need an amendment or an addition on the amendment bill, they can also send through Lindy, so that by the time you come to deal with the clauses, at least we are aware of which clauses can we stick on, rather than to just deal even with all the amendment bill. Am I quite correct? Am I summarizing it the way that honorable members think that we have to summarize it?
I think that's helpful, Honorable Chair, from our. I think that's helpful, Chair, from our side. We will be happy with that. Thank you.
For instance, DG, you are clear about this one of the responsibility, parental responsibility, that most of us have got a question mark on it in terms of the way the 50-50 is. Two, there's also this one of the adoption. The one of adoption doesn't need anything. We are also interested, though it has been answered on why there is a decline in adoption. Maybe Honorable Gizela has just missed it. I listened it carefully on why there's a decline, because all of us were asking why the decline in adoption in South Africa in particular. Okay, honorable members, is there any other hand? Bridget and Lizelle, or Lizelle, is it the old hand?
No, it's a new hand, but I'll follow after Honorable Masango, Chairperson.
Okay. Who's this portfolio committee host?
Chairperson, it's Lindy. My hand is also up. Can I just want to provide a procedural assistance in terms of way forward?
Let's give you first.
Thank you very much, Chair. I just want to explain the process. Currently, we are in a consultative process whereby we provide the department responses on issues raised by all submissions of stakeholders. So that is important, the suggestion by Mr. Stock, that Honorable Stock, that next week, let's give the department an opportunity to take the committee through the matrix. A matrix responds to the clauses as suggested by the department when they table the bill to Parliament. It will provide what certain stakeholders said about that particular clauses, what is the department's comments on that particular clauses, which will make the committee be able to take a decision when they are at the formal stage, which is clause by clause. Now, the process is also to capacitate members, to formalize members on issues and what is the department's stance on a particular clauses. And that does not mean if the committee strongly feels that the position of the department is what they want to see, because the committee, in terms of the constitution, have powers to amend the bill, to reject the bill, and also to appeal the bill. The bus stops with the committee if they want to see some changes in a bill. So now, next week meeting where the department explains the clause by clause of the matrix, it will also capacitate or prepare the committee when they deliberate. The next process, after the consultation process, listen to what the matrix says, and then maybe need follow-up more information on particular area or clause so that the committee can take informed decision. There will be a process, after all, whereby the committee will go clause by clause. The legal advisor will take through, and then the chairperson will put that particular clause to the committee to discuss it in depth and agree on that particular clause. If they feel that they need more information or they need guidance, they can even request the legal advisor of Parliament to go back and make more research and advise and provide guidance to the committee on a particular clauses, whether is it in line with the constitution, the department will be able to implement what will be the consequences if the parliament, propose or agree on this particular clauses. So the ball is on us as the committee, which is the legislature, who have powers to amend, reject, and appeal the bill. So now the process is not for discussion, it's for clarity-seeking question. There will be an opportunity, which is clause by clause, for the committee to discuss and agree on certain clauses. I just wanted to highlight that, person. Thank you very much.
It means we are on track as the portfolio committee. Can I also give to Honorable Masango after Lindiwe has just explained what is going to happen?
Thank you, Chair, and I really appreciate that, and it's good that it came before I just raised my comment. My comment being that, Chair, taking into consideration everything that has been said by colleagues about the way forward, and obviously tied down by the Secretary, I just believe that we do need to have the answers or the responses to the questions we have raised, partly because, from my understanding, says that this is the last part of where the organizations that asked questions have a platform to hear the responses to what they had raised with the department before we get into a formal stage where we then kick in what Lindiwe has outlined and previously Honorable Stock. So my request, Chair, is that we answer the questions. Well, the department, for that matter, answers the questions. Thanks.
Honorable Lizette.
Thank you very much, Chairperson, for the opportunity. Yes, thank you very much for that guidance from Lindiwe, and also the input from Honorable Masango. I would also like to appeal, Chairperson, that we asked a lot of questions. So I think it will be, we will not be doing justice to the process if we don't get answers to the questions we've asked today. Unless we are suggesting that next week we go through the matrix and get the answers that we asked today, and we do that in one session, whereafter we as a committee then maybe resolve, for example, to look into, as Lindiwe had indicated, that we could ask for legal opinion on some sections. For example, as I've indicated, a legal opinion might be necessary on the deletion of section 249 as proposed by the department, as well as the issue of baby savers. But I do want to echo what Honorable Masango said. We do need to get answers to the questions we asked today, because it will be important for us to be guided, whether it's with the matrix and answers in the next session, but that takes place, the answers and the matrix, before we go into the formal clause by clause deliberations, because I don't think those two can really happen on the same day. Thank you, Chair.
That's exactly what Lindiwe was saying. She was saying, if I hear her clearly, next week can be the one of getting the metrics and the answers, exactly as Lizel is saying. Then that other time, after that one, we will also get to close by close. Lindiwe, can you repeat yourself?
Afternoon, Chairperson. As suggested by Member Stock, that it is important for the committee to look at the matrix, where it also outlined each clauses that were proposed in the bill. So I don't know whether we can take the opportunity for the department to respond to the issue in that particular meeting, but it will be a session of this nature. And I think the same question will transpire from the matrix, because it speaks to all the clauses that were presented, but it goes deeper. So that was my guidance as to next week. Let's have a session similar to this nature, but the department take the committee through clause by clause, which is a matrix that respond to clauses. So I think there might be some responses on the question, or the similar question may come from that particular session. So the guidance is on you, Chair, whether you want them to respond now, or we continue next week, or they prepare responses for next week, first thing in there before they present a matrix to respond to the questions that came from this meeting.
Okay.
Thank you, Chair.
Lizelle, is it the old hand?
Yes, Chair, it was the old hand. Apologies.
Okay. Can I? The department was saying they are ready to respond to it, but I could hear that it's not fair the way they were answering, because I don't know. But if the meeting feels we have to get the answers right now, as Lindy has just cleared it to us, that we can get the answers next week. And a similar session like this one will take place in terms of also the metrics. Honorable Masango, are you still saying let's do it now, so that we don't waste time, because we don't have time?
Yes, please, Chair. I just think we can answer the questions today, do the matrix next week, and go on as colleagues have said.
Okay, fine. I'm not rigid. I'm flexible enough. Let's try and see how far we're going to go.
Thank you, Chair.
DG?
No, thank you. Thank you very much. Thank you very much, Honorable Chair. I was just raising my hand to indicate that we were ready to respond to the questions. When I started, I was providing an overview, particularly in response to the issues raised by one or two of the members. So we're happy, and it indicated that we can take about 30 minutes, maybe even less, to respond to the questions. Chair, just on the ECD clauses that you raised, the concerns, I want to just indicate that Leander may have put it in the way in which you put it, but indeed we are able to respond to every issue relating to ECD. We're just saying that because it will be dealt with in the second amendment, we would deal with it there. But if there's specific questions, indeed, we're happy to take those, Chair. Let me then advise how we will respond, Chairperson. I would like for Neliswa to go first on the questions around child protection and the CYCCs. Immediately after Neliswa, I'd like Kumbula to go on the issue of social workers, as raised by Honorable Opperman. I think it was Honorable Opperman, yes. And then the issue of fathers, as raised by Honorable, I think it was, okay, I can't remember the Honorable members, but on the issue of fathers, I would like for Percy to respond to those issues. Dr. Mabe on the issues around adoption, and who am I leaving out? And then Leander and I will come back at the end. If there are any additions, Isabella will make any additions. So in that order, please, colleagues. Neliswa first, followed by Percy, then Dr. Mabe. Please go, Neliswa. She is virtual.
Good afternoon, Honorable Chairperson Mamuvana, Honorable members, DG, and colleagues, and our Honorable Minister, good afternoon. I will be responding to the aspect on issues of abandonment, especially in relation to Section 150, which deals with issues of, orphaned children in the care of family members. We have supported that part as the department, because our Section 150, it has really considered that and also made provisions to ensure that there are other control measures in place to ensure that we don't lose our children within the child protection system. Therefore, they should be receiving the basket of services, such as our community-based prevention and early intervention programs, which is the RESIHA, as well as the implementation of the extended child support grant. The part that we indicated that we are not supporting, it is the Section 159, and which brings the part of the transitional mechanisms, because we are saying that it's already catered for in terms of the Section 48, because the judiciary do have such powers of, making those extensions based on the assessment of children that are still in alternative care. But these two aspects, they have also been covered in the metrics that we have provided. And the issues of safe abandonment in a form of approving safe, I'm not sure whether it's safe boxes. We are saying that we do have safe havens. Thank you for that, Honorable Member. In terms of the issues of safe havens, the Children's Act makes provision for temporarily safe care, which we're saying that it should not be more than 6 months, because we must ensure that if a child is, reunifiable with families, or is eligible for adoption, or going to foster care, or in the children's home as part of alternative care, such children should not then stay longer in temporarily safe care. Hence, we say 6 months in temporarily safe care. There was a question raised around, the implementation, that the Act, as much as it is in place, it is not transferable to implementation. That is why we also have provisions of national strategies as well as provisional strategies in certain sections of the Act, which we know that such sections requires that we must have the resources, mechanisms, and systems in place to ensure that the Act is implemented in totality, and that section does yield the required, and making impact in people's lives. If we've got strategies in place, which of course needs that closer monitoring. There was a question as well on the audit or studies that have been conducted in child and youth care centers. We did have a study in 2010 and again in 2012, which was basically looking at the issues of registered facilities. I can safely say that as in September 2021, our audit indicated as well, because we also conduct a quarterly assessments and monitoring of our child and youth care centers. Nationally, we've got 449 with this distribution. In Eastern Cape, 24 facilities, Free State, 59, Gauteng, 165, KZN, 78, Limpopo, 21, Mpumalanga, 22, Northern Cape, 11, Northwest, 7, Western Cape, 62. As I'm speaking about these registered facilities, I need to contextualize that it is within the context of the 3 different programs that are offered. That is temporarily safe care, second, a program, reception care, development not in the family environment, and the last program is secure care of children with emotional, behavioral, and psychological difficulties. And I must indicate, Honorable Chair, that this is not about children in conflict with the law when I speak about these secure care facilities. And the distribution in terms of those temporarily safe care, with the bed capacity that was also asked by the Honorable Member. The bed capacity, I must also indicate that doesn't mean that is the actual number of children that are in temporarily safe care, but I'll also give the latest statistics of the actual numbers of children in the temporarily safe care as based on our monitoring in 2021 September. The bed capacity for temporarily safe care is 3,337. And that also fluctuates because it's dependent on the movement of children, because it is temporarily safe care. As we say, that children should not be in temporarily safe care more than 6 months. However, it's also dependent on the court that has to finalize the placements of children. And then the other program, which I'm going to use the old name, and I know my colleagues in child and youth care centers won't be happy with me, because we are actually saying that it's child and youth care centers, all of them, but the old children's home, the number that we have in terms of the bed capacity, it's 15,552. And then for the secure care for those children with behavioral, psychological, and emotional difficulties, it's 912. Therefore, the total bed capacity that we have as the country in our CYCs is 19,801. But the actual that we have as in September, because as I indicated that it fluctuates because children move in these places. So temporarily safe care, it was in September 2,522. That is the actual now against the bed capacity. For children's home, 13,240. And Honorable Chair, for the secure care for children with emotional and behavioral, it's 551. So against the bed capacity of 19,801, the actual that we have in our CYCs in terms of these three programs I've mentioned is 16,313. And I must mention, Honorable Member and Chairperson, that it's important that we understand that the establishment of facilities in different provinces is based on the assessment and needs that the province, identify. But based on what we have seen, that the bed capacity is 19,801, but the actuals that we have, it's 16,313, meaning that we do have, some spaces in our facilities to accommodate our children. However, the courts also determine if the facility has got a suitable program for that child to be placed in that particular facility. I think I will hold you there, handing over back to DG and the lineup that he has outlined. Honorable Mamumvana, thank you.
No, thank you very much. Thank you very much. Okay, I'm going to ask Percy to go now. Percy is responding on the issues with regards to fathers.
Thank you, and good afternoon, Honorable Chair and honorable members of the Portfolio Committee. I'm just going to quickly talk about the issue of parental alienation. I think earlier on in Mr. Advocate Producer's high-level summary of our presentation indicated the fact that while we welcome the suggestion that there should be a definition of parental alienation, however, we felt that that has been included in the definition of child abuse. But also from the side of the department, we have since realized that the reason there is so much parental alienation is because of the fact that there is no communication between parents. Therefore, we have since suggested that we need to put measures in place in order for us to be able to address that or mitigate that. So one of the issues one of the measures that we've decided to put in place to ensure that before we talk about mediation between the two parents, it is important that there should be communication between the parents first, because we've realized that you cannot mediate if people do not communicate. So we are putting those measures in place to be able to address the issues around parental alienation to mediation, because we understand, and this is some of the issues that were raised by fathers, that litigation is very expensive. So we want to explore other means of trying to resolve the issues between the two parents, because it's of no good when parents share the responsibility of raising the child and yet there is no communication between the two parents. So I think that should be our starting point. But also on the issue of the 50-50 rights, we support that. However, I think we all should move from the premise that the interest of the child is of paramount importance, and therefore 50-50 rights cannot be automatic. Especially where the father was not there when the child was born, or where the child has not satisfied some of the requirements in Section 21. And I think we've also indicated the fact that we have amended Section 21 by removing "and" and replacing it with "or," because we say if the father satisfies either of the four requirements, therefore the father has the right to have, access to the child. So on the issue of social fathers, I suppose the honorable member was talking about the instance where children do not have fathers, maybe due to death or any other reasons. We do have in practice where you will have children being raised by either relatives, teachers, or community leaders. However, the only thing I think that is missing is whether they do have any rights and responsibility, over those children. I think this is one area that maybe we need to consider moving forward. And the other issue that was raised also by the honorable member of the committee was the fact that how come fathers or some of the fathers only take responsibility when mothers have passed on? I want colleagues to or maybe inform colleagues, about what we call maternal gatekeeping. This is a situation where mothers deny fathers access to the children for various reasons. And I think I would like to propose that colleagues read a research document that was commissioned by the Commission of Gender Equality. And the title of the document is When Relations Disentangles, so that we can have an understanding as to why fathers or why most fathers do not really take part, in and also, now I'm overstepping my role as requested to talk on issues of fathers. I think Honorable Masango also indicated, especially she was talking on the issue of adoption with regards to abandoned child or children. And she said that these children normally do not have families. I stand to differ with that because when the child is abandoned, that doesn't necessarily mean that the child does not have family. What it means that the child doesn't have a parent or mother or a father, but child does have a family, and that can be considered for adoption.
Percy, just talk into your mic a little bit more, please.
Oh, sorry. Where do I start?
No. Proceed, Baba. Proceed towards the end.
Oh yeah, I was almost done, but I think what I want to assure the honorable members of the committee is that we are hard at work in ensuring that we address some of the issues. Maybe some of them may not really fall within the scope of the Act, or maybe some of these issues has got to do with the implementation, but the Act does make provision, for fathers to also have access. What we need to do is to upscale, our awareness, in terms of ensuring that unmarried fathers do know their rights and they do know that there are various remedies or legal recourses that they can follow to have access to their children. Thank you.
Yeah. No, thank you very much, Percy. I suppose Percy was not directing members of the committee to the publication that he made mention of, but he was simply suggesting that it would be a good read where possible. And I think if you have a copy of it, can be shared with the committee, because I think it will be useful. So I just want to indicate, Chair, he was not directing members of the committee, but he was simply making a suggestion, unless it is read, in the event it is read otherwise. I will now ask Joyce to respond to the issue of street children, and let's try and be as swift as possible. Joyce.
Honorable Chairperson of the Portfolio Committee, honorable members, the acting DG and colleagues, thank you for this opportunity. The question around street children was basically about how they are removed from the streets. Let me begin by referring to the definition of a street child, because then this definition is going to support how we remove them from the streets. Section 150, subsection 1, letters A to I, gives a definition of a child in need of care and protection. So that list from A to I, it's identifying children and defining them, those that are found to be in need of care and protection. And specifically, a street child is defined on letter C, which says a child in need of care and protection is a child who lives or works on the streets or begs for a living. So a street child is also listed with other categories of children who are defined to be in need of care and protection, meaning the abandoned, the abused, the neglected. Then we now come to how they are removed. I must say the process that is followed when removing the children from the streets is basically the same as those of the other categories of children that are defined in subsection 1 of section 50. Section 151 speaks about removing children with a court order, and that basically happens to children from the streets. And section 152 details how we remove children from the streets without a court order. And in that instance, the situation should rather be very threatening to the child. So they are treated, as other categories of children who are found to be in need of care and protection. So I want to refer the honorable members to sections 150, 151, and 152 of the Children's Act. That will give the people the idea or the knowledge of how children are removed from the streets. Thank you, Honorable Chairperson, and thank you, Acting DG. Thank you.
Thank you, Ms. Joyce. I'm going to ask Kumbula to go next on the question of the social workers. Thank you.
Thank you very much, Chairperson. We've got plus minus 78,000 social service professionals registered with the council. Of these, 35,000 are social workers in the NPOs, CSOs, as well as the private sector. In terms of our sector, which is this department and the provinces, we've got 17,508 social workers. Between October and the end of this financial year, we recruited on contract basis 2,473 social workers. And the bulkiest number of these are in Gauteng as well as KwaZulu-Natal. Gauteng having 1,026 and KwaZulu-Natal employing 967. I will come back to the committee on the statistics for auxiliary social workers and CYC, because I still need to confirm these figures, but it ranges around 25,492. Thank you very much.
Thank you, Kumbula. And those are the ones that are actively operating at the moment, or working at the moment, that we will respond to. Thank you very much. Chair, just two more responses quickly. Dr. Mabe.
Thank you, Acting DG. In terms of questions relating to adoptions, I will start with the one that relates to the monetary, assistance. Whether is there a monetary assistance when one has adopted a child, vis-a-vis, the foster care grant. We don't have monetary assistance, but we encourage, that if your parents, are or do want, assistance, they are eligible, to can apply for what we call, child child support grant, in that regard, they are also, eligible, to get, such assistance from government. That is one. The second question is in relation to the mentioning of the decline of adoption figures, to say the presentation was more on intercountry vis-a-vis, the national or domestic. I must say the decline covers both programs, being national adoption, stroke, domestic adoption. It has also declined. But the slide was concentrating much on intercountry because it wanted, to give background and context in terms of sending children, from South Africa to other, countries. But I must say, we have records, according to our adoption figures, to say both national and intercountry, figures have declined. So that is in relation to the decline in terms of figures. The third question is in relation to the capacity. Do we have capacity as government, to render adoption services? The question is yes. As we speak, we are having 509 social workers who are registered with the council to render adoption services. So we have a caliber of trained social workers who could be driving, the service and offering, the service forward. There was also a question to say, can we provide a list of countries benchmarking whereby, government is taking a lead in terms of adoption services? Yes. There are various, countries in Africa. I must say, South Africa, is the only, country that is, having a hybrid, model in terms of offering both government and private, services. In countries in Europe, we have countries like Australia, whereby most of adoptions are being rendered, by government. There was also a mentioning of unpacking the intersectoral nature of the process, of adoption, to say, where do we as social development zoom in terms of our services? We come in as DSD, in the initial stages of screening, offering counseling, matching, parents with children, facilitating bonding and placement. That is where we come in. Other government departments, for example, the SAPS, come in terms of tracing the parents, of children, and also, generating what we call police clearance, because that is also, a requirement, in terms of the process. From there, Department of Justice, whereby we present, all matters before the presiding officers, and then if at all the presiding officers, satisfied about what the social workers would have presented in the report, they grant what we call, adoption orders. From there, it comes back to us as DSD to register those cases in what we call adoption register, so that we would be knowing how many cases do we have, how many children have been adopted across, the country. From there, there is also a department, Department of Home Affairs, that is also implicated at the tail end, whereby we would refer, the parent to go and approach the department in terms of effecting the name changes, in terms of the new surnames, the new names, if at all, they are such. So I wanted, to put or portray the intersectoral nature of the processes, because they are various role players with respective roles and responsibilities, for them. So I guess, Acting DG, those are some of the questions that I have noted for now. Thank you.
Thank you very much, Dr. Mabe. I'm now going to ask Leander to respond to some of the issues that were raised very quickly, Leander. Thank you.
Okay, thanks, DG, and thank you, Chairperson. Again, let me just go briefly through the questions. The first one will be about the age issue. We have taken note of the challenges that relate to age as to what a child can do at a particular age. And we are of the view that it is not a matter that can easily be legislated in terms of the Children's Act, because we've got different age requirements for different transactions across the sectors. For an example, a 14-year child can witness a will. A 16-year-old can consent to sex in terms of the Sexual Offences Act. A 7-year-old and below does not have criminal capacity. You see, with regard to those, and then a 16-year-old can take a will. I'm sorry, can take a life policy in terms of the insurance law, because of the nature of such an engagement. It is not very easy to say in the Children's Act, this is what one can do with regard to the difference in ages, but to let the status quo remain. But if we were to amend the legislation because of a pressing issue, maybe we would need guidance from the Law Reform Commission, which would be able to assist in the harmonization of these age differences with regard to the different transactions they relate to. The issue of may and must, I think, is the one that DG has responded to, which was talking to the database of the NGOs and NPOs in our system. The issue that we're raising here was that it is not easy to say the provincial MECs must provide funding to NGOs, because it is difficult to do so, or dangerous, as there are so many new emerging organizations that are coming on board. So on such basis, that is the difficult that I was referring to, not that we do not, as a department, have the record. With regards to the deletion of Section 249, the reference to 249 is actually a verbatim quotation from what people who were raising the issues were referring to. Actually, is 249(2). That is subsection 2B and D, that make reference to fees, the charging of fees. That is what we are referring to, and any such other provision as a consequential amendment, not the entire 249, because the other provisions are okay. The other issue is around China and the issue, and Russia is an example. We are not Chairperson saying, let us copy from China, or we must copy from Russia. What we are saying is that there is a lesson that has to be learned from what other countries are or have identified. And it may not be the case with us in South Africa, and we may take decisions along those lines. But what we are rather saying is that it is very difficult for us to allow a situation or a bad situation to take place before we act. What we are saying is that the nature of this department is more proactive and preventative in nature. It is much better to prevent, if I may link that with the issue of child trafficking that was raised by Honorable Van der Merwe, to say, yes, we may not have a study that we have conducted as a department to say there's a link between child trafficking and inter-country adoption, but it would not be wise for the department to wait until there is a case of child trafficking and then start amending the legislation. We believe that prevention is better than cure. So the earlier we act, the better as a department. One child lost in trafficking is much too many. So we are more proactive in this regard. Dr. Mabe has responded on various issues that have already been, dealing with adoptions and all that. So basically, these are the issues that we are dealing with. And we are also saying when Section 249 is deleted, we are not saying child protection organizations are not going to be able to do adoption cases, but rather the department itself will also be able to deliver the same service that the child protection organizations are dealing with, so that a person there has got a choice whether to approach a child protection organization or to come to the public service for that kind of a service, because the service is very expensive when it's dealt with privately. So we are giving people a choice to deal with this. Yes, we may not have at present the proof that says there is so much money involved, but when one views the websites of the child protection organizations across the world, the fees are there, they are flighted there to say this is how much a child protection organization is charging for transacting an adoption case. So what we did as a department some time ago was to develop guidelines for inter-country adoption. And in those guidelines, we also have a case where we say child protection organization must submit audited financial statements to the department so that we can easily see whether there is too much money coming into their accounts, in trying to monitor the whole issue of possibility of using money for adoption purposes. But I believe that has never materialized. I've never got a brief that a single child protection organization has ever submitted to the department audited financial statements as required by those guidelines. So thanks, Chair Forum.
No, thank you very much, colleagues. Chairperson, I think that summarizes our response to the matters raised by members. And we once again would like to take the opportunity and thank the opportunity for the session. We will leave it at that for now, Chair. Thank you very much.
Thank you, Acting DG. I see Honorable Masango's hand is up.
Thank you,
Honorable
Chair. Thank you very much, Chair. I'm really sorry to do this. It's unprecedented in my case. I just missed the question that was answered that I had asked about the abandonment. And I want to be sure that the response said that a baby that has been abandoned in a door of hope or something like that, a family can be found. Is that what the answer was saying? I just wanted to confirm that, Chair.
DG. DG.
Yeah, no, thanks, Chair. Percy, can you quickly respond to that one? Thank you.
All what I was saying was that from the honorable member's question was that I think it was in relation to the issue around adoption, was that maybe inter-country adoption should be considered where the child is abandoned, where the child does not have family. So what I was saying is that if the child has been abandoned by a mother or a father, it doesn't necessarily mean that the child does not have a family in the country. Therefore, first preference must be given to the extended family in the country rather than moving the child from the familiar surrounding to another country. That was my response. I don't know whether I understood the question correctly. Thanks, Chair.
Okay, thank you. Seemingly there are no other hands for now from honorable members. I wish to thank the team and the DG for the responses, but we're pressed of time now, and we are not yet finished with our agenda. Lindy?
Chair?
Yes. We have to be out by past later. That's the latest. Otherwise, we are supposed to be out by 1 o'clock. And it's already past 1.
We are in your hands. If the committee wants to proceed and adopt minutes, we can do so. Maybe we can defer them to the next meeting. So it
or is it 4 sets of minutes?
Yeah, Chair.
Okay. Maybe let's allow the department to be excused and then deal with the minutes.
Thank you very much, Honorable Chair.
Thank you very much, DG and the team. Can we then go to the minutes? We must be finished by past, Lindy.
Thank you very much, Chair, for the opportunity to consider the minutes. We have only 4 sets of minutes for the 16th of February, which is our first meeting. And then the second set is for the 23rd of February. And then we have a set where we were with SALGA the 2nd. You know, we were with Home Affairs and Justice Department, which was the 2nd of March. And then we have the 4th of March, which was with SALGA, and last week minutes, a chair where we had we were with I don't know. No, we have a joint committee with PC on basic education on migration. So I don't know whether, Chair, you want to go as per date now that the minutes were circulated to members, or you want me to screen them to display them. So I just need your guidance whether we can just name the date and then we request the mover and the seconder if there are issues.
The first one, Lindy, is for the 3rd.
Is for the 16th of February, Chair, our first meeting.
16th February.
Yes, Chair.
The second one?
Is for the 23rd of February, Chair.
Yes. The
third one? The third one is the 2nd of March.
Okay.
And the
last one?
The fourth one is the 4th of March with the SALGA.
Okay. Okay. Can you just flight them so as members are able to just remember, but they are very old. (16th February).
Yes, Chair.
Okay. What? Yes, we do. We have received them. Okay.
Yeah, on this meeting, our first meeting was with Professor Skelton, where she presented the issue of age majority and also the representation from the content advisor. And then we adopted the provincial reports in the program. So it was not a long meeting, and the members engaged with Professor Skelton on the presentation on age majority. and the committee satisfied itself and got clarity on the issues that they were not clear of. So that was in a nutshell, as well as you represented the provincial reports and as well as the key issues that emerged from the provincial public hearings. There was a long presentation. So that was the meeting in a nutshell, Chair.
Thank you, Lindy. What are members saying on these minutes?
Person, this is Bridget. I would like to move for the adoption of the minutes. Thank you.
Bridget, Honorable Bridget, move. And then second.
Thank you very much, Chair. It's Honorable Shaw. My hand is up. And I second the adoption of the agenda of the minutes.
Okay. Honorable Stembile Mhlongo, seconds. Thank you very much. Honorable members, 23rd February, flight them, Lindy.
Okay, Chair. 23rd. Where's 23rd? Sorry, Chair, I just opened them now. Where's 23rd? Sorry, members, just 1 minute. 23rd. Can you see?
Not yet.
Not yet. Okay. Can you see now, ma'am?
Yes. Yes.
Okay. This one was the department, that short meeting where the committee agreed that the department's presentation was not satisfactory. So the department was sent back to come and work on their presentation. And then we adopted the minutes, about 6 to 8 sets of minutes, 6 sets of minutes. And that was that meeting in a nutshell.
Thank you, Honor Lindy. Can I get the indication of moving those minutes?
I'm moving, Chair. I'm moving.
Oh, Jane, Honorable Manganye moves. Seconder. We only dealt with minutes because the department has been turned back.
I'd like to second.
Bridget Masango seconds. Thank you very much. The minutes of the 2nd March.
Okay, Chair. I'm going now. Second March. Okay. In this meeting, Chair, there was a briefing from 2 departments, which was the Home Affairs and Justice Department, as well. To respond on issues raised by the stakeholders on the Children's Amendment Bill. The committee engaged on this particular presentation from both departments.
Okay.
On this one, I was in the study leave, I remember, but I think it went very well.
Yes, where Home Affairs and Justice Department were presenting.
Yes.
Can I get any mover for?
Chair, I move for the adoption.
Okay, thank you. Honorable Mhlongo moves. Any second, comrades? Honorable members? Okay.
I'm seconding.
Jane, with the meetings of the second, the last one. Is it the 4th?
Yes, Chair.
4th March, yes, the last one. The meeting with Salga.
Chair, this one was the meeting where we invited SALGA to respond on issues raised by the stakeholders in the Children's Amendment Bill. We had Nozi Makanda, who made a presentation and took the committee through the issues, and the committee deliberated and make few resolution on the presentation.
Okay, those ones are still fresh in our mind, where SALGA was, in fact, they did their presentation. Any mover for these minutes?
I move for adoption, Chair. Honorable Opperman.
Thank you, Honorable Gizel. Seconder, any seconder? I can't second the minutes of myself.
I would like to second, Chair.
Masango, Honorable Bridget, seconds. Thank you very much, honorable members. I think we are done within 15 minutes time with the minutes. Then let's adjourn the meeting so that we can quickly log on for the House. Thank you ever so much, honorable members. You were so good. It was not an easy meeting. Thank you. The meeting is adjourned.
Thank you, Chair.
Thanks.
Chair. Thank you.
Lindy?
Thank you, Chair.
Lindy,
Salon?
Can we send a get well words to the DM?
Okay.
Last time. Yes,
okay,
please.
I'll ask Tani to do so. It's your responsibility. I'll remind her and assist
Okay.
her.
Thank you very much on behalf of the committee. Thank you.
No objection.
God bless. Bye, honorable members.
And staff. Bye.
And staff.
I'm
sorry for that. I always forget to really thank them. They are doing a sterling job. Thank you very much. Our backup.
Thank you. I'm going to end the meeting for everyone. I don't want to be rude. Can I?
Yes, please.
Okay, thank you. Bye.